Amber, any what? Oh, okay. Normally they're on like 30 minutes in advance, testing microphones and stuff like that. So, okay, all right. Okay, thank you.
All right, council, this is Susan Shaver. I'm the staff attorney for the business court. We're getting ready to get started. Is everybody here? Can everyone hear me? I'm going to ask you to acknowledge verbally.
Yes, I can hear you, Ms. Shaver. Can you hear me?
I can hear you.
Okay.
Ms. Watts?
Yes, I can hear you.
All right, I'm going to go ahead and let Judge Goger on the line. Do you have any questions before we start?
Well, we are still waiting on the plaintiff's lawyers and the court reporter.
All right, let's see. There are people waiting to enter. Give me 1 second.
Okay.
All right, this is Susan Shaver. I'm the staff attorney for the business court. I'm getting ready to let Judge Goger on the line, but I wanted to make sure that everybody's here and that we can see and understand everyone. So I've just talked with the lawyers for the defense, lawyer for the plaintiff. Can everybody just acknowledge that they're here and that they can hear? Can you acknowledge verbally, please?
Yes.
Yes.
All right. All right. And I will ask the witnesses, are the witnesses all parties? Are they all present?
It appears to be the case, Ms.
Dr.
Shaver.
Maida.
Yes, Dr. Maida is present.
Okay. I'm going to ask, if you are not a lawyer who's going to be speaking during the hearing, I'm going to ask you to mute your video. Or mute your sound. All right. So is there anyone else that we're missing that you can see that we need to? All right. I'm going to add Judge Goger to the line.
Ms. Shaver, I don't see the court report. Oh, sorry. I do see her now. Sorry. Yes, then we do have everybody.
All right. Well, let's acknowledge who. Is that Ms. Stone? Who's the court reporter?
Miss Taylor, Miss Sarah Taylor.
Oh, okay. Ms. Taylor, if we ever get to a point where you cannot hear or you have any trouble following the proceeding, I want you to get very vocal, okay?
Okay, no problem.
You understand? All right. Thank you.
Yeah, no problem.
All right.
Judge
Goger, I think we're ready for you.
Morning.
Good morning, Judge Goger.
Okay. Some of you appear to still be on mute. Sarah, Meredith.
Morning.
There you go. I've got Sarah. Everybody else want to do a little sound check for me so you're not just moving your lips when you speak?
Sure. Judge Goger, this is Mike Kaplan. I represent the plaintiff along with Julia Stone. I will be making arguments on behalf of the plaintiffs this morning. If we have witness testimony, my colleague, Ms. Stone, will be examining the witnesses.
Good morning, Judge Goger.
Who else wants to make an announcement?
Good morning, Judge Goger. My name is Meredith Watts, and myself, along with my colleague Annie Kayola, are here representing the defendants. I will be presenting the argument on the motions, and Ms. Kayola will be handling the examination of the witnesses.
And I would be remiss, Your Honor, if I did not introduce my client, Dr. Mary Maida, who is also on the phone. She will,
Morning, Your Honor.
Morning.
Of course, appear if you hear testimony today.
Great.
And I'll give her a further introduction during my argument.
Yeah. All right.
And Your Honor, we also have the CEO of Clerisy, Mr. Rossland and James, here with us today.
Morning, Your Honor.
Now, tell me about the witness situation. Where are the witnesses?
Your Honor, the plaintiff's witness is, I believe, in her home, Dr. Maida, in Rochester, New York.
Fine. She's a party.
And I believe Mr. Lyndon James is in California.
Okay. Very good. But he's not tuned in right now, correct?
No, I am tuned in.
You are tuned in.
Yeah.
Now, tell me, what is your position in the company?
I'm the Chief Executive Officer of Clerisy Corporation.
So you're here today as their representative, is that right?
Yes.
All right, good. Okay, are those our witnesses? Anyone else? Anybody expect to call anyone else?
Not for the plaintiff, Your Honor.
All right.
And not for the defendant.
Well, let's begin. It's your case. I'll ask for your suggestions as to what you think is the correct order. I have my own ideas, but let me hear from you. We'll begin with you, Michael.
Thank you, Judge Goger. Well, my suggestion is that Your Honor hears argument from the parties first. We have filed a motion for judgment on the pleadings, which, of course, if granted, would dispose of all of the issues in the case. In my argument, I could also address the first two arguments we make in response to the motion for preliminary injunction, which concern latches because the motion was filed 10 months after the assignment at issue, as well as mootness since the intellectual property has already been the subject of encumbrance. Those are two, so all three of those are threshold issues to the preliminary injunction motion. It may not even be necessary for you to hear testimony and sort of go through what could be a pretty lengthy day if you decide to either grant the motion for judgment on the pleadings, which we certainly hope you will do, or in the alternative, if you find either of the two threshold issues that bar the motion for preliminary injunction. So I would suggest that we have fulsome legal argument first, and then you make a decision as to whether you want to hear witness testimony today or issue an order on the legal issues. And then if witness testimony becomes necessary, we can do it then. But it's not like this is some emergency. That the motion was not filed, like I said, until 10 months after the transaction. So that's how I would suggest we proceed.
And someone who we need to acknowledge is with us, Sarah Taylor. You're our court reporter, is that right?
Yes, sir, I am.
Okay. Since this is being taken down, I want everyone to be conscious of that, so speak slowly. And if you get yourself speeding up, you may also be looking at a funny transcript when it's all said and done. And Sarah, if anybody, I'm sorry, Ms. Taylor, if anybody, is speaking too fast or you're having difficulty keeping up, just let us know and we'll stop and get that so we get the record straight.
No
Okay,
problem.
Meredith, I guess you would be next, yeah?
Yeah, we're agreeable that that the motion for the judgment on the pleading should be heard first. I think that that's obviously a threshold issue, and I think it's important for the record to kind of keep the two motions separate for a clear record. And so we would be agreeable that the motion for or judgment on the pleadings would go first. We would obviously disagree with Mr. Kaplan's characterization of the motion for injunctive relief, but we'll save that argument when we get into it.
Yeah, and on the question of witnesses, a lot of this deals with the law, and to the extent there may be conflicts in people's view of the facts, I don't know that we'll necessarily need them. I'm hopeful we can do this without witnesses, but we'll find out. So, all right, with that, let's begin, Mr. Kaplan.
Thank you, Your Honor. If it would permit or be permissible to the court, I would like to share my screen. I have prepared a PowerPoint presentation that includes some of the relevant material.
Fine, thank you. Go ahead.
Okay. Okay. Your Honor, do you see the first slide on your screen?
I do.
Okay, wonderful. And is it, well, now sorry, has it now switched to the second slide?
If the second slot is the parties, and I see number 2 at the bottom of this page, I assume that's it. So yeah.
Wonderful.
Yeah.
Okay, we tested this beforehand, but I wanted to make sure it works.
It looks just fine, and go right ahead.
Okay. Well, so Your Honor, before I begin by introducing the parties and the case, I really want to just give a very high level statement about what this case is about. It is a simple case about a promissory note for which not a single dollar has been paid, and a promissory note that both Dr. Maida and Dr. Felton are entitled for payment. And as Your Honor surely knows from your many years on the bench, Georgia law is very clear that once we introduce evidence of an enforceable note, the burden shifts to the other side. The rest of this case is an effort to distract, to delay, to protract, to increase the expense on my client, to leverage a potential discount on the unquestionable amount owing under this note. What we ask for today is that you rule in our client's favor that this note is enforceable, enter judgment against the defendants for the undisputed amount owing under the note, and dismiss the remainder of these claims, which are, as I said, nothing but efforts to distract and are frankly not actionable for the reasons that I will go through. So the way that I plan to make my presentation this morning is to first talk about our affirmative claims, the note, and then I'll spend some time on the counterclaims for which we seek judgment as a matter of law as well.
Okay.
Dr. Maida, who is with us today, is a very distinguished professor of neuroscience at the Rochester School of Medicine. She also founded the company Clarity, which was really her company's and her work around designing a patented device that uses nasal strips to deliver medicine to a patient. The particular purpose for this device was to be for the delivery of medical cannabis, although the device has never been produced, manufactured, or even invested in by Clarisy because they never put the effort into it. Clarisy and I mean RxMM, the company that ultimately acquired Clarisy. The defendants in this case are Clarisy, which Dr. Maida and Dr. Felton sold, and RxMM. Dr. Felton, who's not with us, is Dr. Maida's husband. He is also a very well-known dean, professor of neuroscience. He also won the MacArthur Genius Award and has, of course, been involved in the development of this technology. Now, what are the undisputed facts in this case? Well, in April of 2016, Dr. Maida, Dr. Felton were approached by the individuals who represent RxMM, who asked to purchase Clarisy and the technology, the patents that Clarisy had obtained. The parties entered an agreement, which was primarily an agreement that required RxMM to develop the product and then pay Doctors Felton and Doctors Maida. They had essentially 6 months to come up with the money, which was approximately $1 million, and that was due October 31st of 2016. In addition, Doctors Maida and Felton were given stock in the new company that acquired their company. Now, within 6 months, RxMM failed to make any payment to Dr. Maida or Dr. Felton. So that's really when all of this began, was in October of 2016. For years, for literally 2 years, Doctors Felton and Doctors Maida tried to work with the company to encourage them to raise the capital necessary to develop the product, in an ultimate effort not only to be paid, but also to see the company success. That effort failed. As I said, nothing was ever done to invest in these patents. And actually, RxMM permitted these patents to expire. They didn't even do the work necessary to maintain the status of these patents with the United States Patent Office and other offices. That's when we were retained in this case in mid-2018, when Dr. Felton and Dr. Maida realized that they were not going to get paid by their repeated efforts to work this out themselves. So we, of course, sent a demand letter and said, this money, this approximately $900,000 is owed and it needs to be paid. That ultimately led to negotiations where we entered the first forbearance agreement and the first negotiable promissory note, which required that RxMM make a payment within 3 weeks of the execution of that document in December of 2018. Remarkably, despite having entered that agreement, within that first payment was not made by Clarisy or RxMM. They also continued to fail to make the ultimate balloon payment that was due under the first promissory note and first forbearance agreement in June of 19. Clarisy and RxMM continued to make us assurances. Of course, we were reluctant to have to bring this litigation to incur the additional expense involved. And so we negotiated yet a second forbearance agreement. But this time, we made it very clear to Clarisy and RxMM that we were not going to just enter into another unsecured promise. This time, the only way we would continue to forbear from suing and obtaining a judgment was if Clarisy and RxMM pledged the intellectual property that Dr. Maida had sold years earlier so that she could get it back if they yet again failed to meet yet another promise. So that's what led to the execution of the 3 documents that are before this court. The first is this amendment to the forbearance agreement. And important to that document is section 4.8, which required within a week that Clarisy and RxMM pay $42,500. That's section 4.8. And I'm emphasizing this because you're going to guess what happened a week later. It also required a payment of $225,000 in October of last year, and required that Clarity and RxMM deliver yet another note that required payment of the remainder of approximately $650,000. So that's the forbearance agreement. The note itself, which was a $655,000 note, was a note that frankly was generous in terms to RxMM, 7% interest with a 12% interest default rate, and a clear payment schedule that required 4 payments of $163,000 in December of last year, March, June, and September of this year. I'm sure you can also predict whether those payments have been made. The default provision in the note makes very clear under section 6.1 that a failure to make payment of any of these amounts due automatically results in a default. Now, you've heard in some of the papers, and you'll probably hear today, RxMM argue that they had yet an additional 30 days to make these payments because of a notice requirement. But that's wrong. The notice requirement is actually under section 6.3. As you can see, the very last sentence in that paragraph says that if a breach of a covenant, an obligation or condition is unsatisfied, and that lasts for 30 days, such a breach of covenant constitutes a default. So this agreement, as many of these kinds of agreements, distinguishes between monetary defaults for which there's no opportunity to cure, and then there are non-monetary defaults, which do allow for 30 days. Now, when we sent default notices in this case, we gave them 30 days in part in an effort to try to get the money. But the fact is that they didn't just get an additional 30 days to pay money that was due at the time it was due. A default occurred automatically and without notice under the plain terms of this agreement. Finally, we signed this pledge agreement for the intellectual property, also in the record, which makes clear that we have a security interest in all of the intellectual property at issue. There's been no dispute in this case that we have that security interest. We've highlighted the language that it is absolute and unconditional. We are the first and only secured party with respect to that interest. And most importantly, in the event that RxMM defaults, we have the right to immediately seize the intellectual property. And that right includes, as I've underlined in red, holding it, collecting it, selling it, leasing it, delivering it, granting options or purchase, retain, liquidate, or dispose. And in fact, this security agreement even goes further and appoints Dr. Maida as an attorney, in fact, that authorizes her to assign the IP to herself, in the event of default. So, I mean, this is the strongest form of security you can get in intellectual property. That was the only way we were going to give RxMM additional time in which to pay a debt that it has owed since 2016. So what happens after we signed this agreement in September 2019? Well, amazingly, within 7 days of signing the agreement, RxMM failed to make the first payment due of $42,500. Instead, without even giving us the courtesy of an explanation, they made a payment of $20,000. They have yet to ever pay that additional $22,500. Again, the next payment came due on October 31st. And once again, RxMM failed to make that payment of $225,000. So you can imagine, at this point in time, our clients have spent 2 years trying to work with this group. They've never been paid a dime. We get hired. We negotiate multiple agreements incurring fees. We reluctantly agree to yet a second forbearance. And then within a week of having signed the second forbearance, we don't even get the first payment. If there were fraud in this case, the only, I think, actionable fraud would be a situation where somebody makes a promise to make a payment 7 days later and then fails to make that payment 7 days. I mean, but we have an alleged fraud because the simple fact that we want, or the simple relief that we want in this case, is merely the judgment to which Dr. Maida and Dr. Felton have been entitled to since 2016. So what do? This time we decided that we would be a bit more serious. And so on November 1st, we sent a demand letter. As I said, there was no 30-day period to cure. This was a monetary default. And we said, not only do we demand that you make payment, but we need you to go ahead and assign the intellectual property that we already have the right to obtain ourselves under the security agreement. And ultimately on November 5th, understanding that they had no choice because it was our legal right, RxMM executed an assignment of this intellectual property, giving it back to Dr. Maida. Now, one other thing I want to emphasize to Your Honor, because this isn't really pointed out in great detail in our papers, is the substance of that assignment agreement. This is a copy of the assignment agreement. And most importantly, on the second page, where the patents are assigned back to Dr. Maida, at the bottom of that page, there is a merger clause. And I've highlighted that on the bottom of your screen. It says, quote, "This assignment constitutes the entire understanding of the parties and revokes and supersedes all prior agreements between the parties and is intended as a final expression of their agreement." So this merger clause means, under Georgia law, that RxMM cannot rely upon extra contractual statements as a basis to claim breach of contract or anything. And as I'll talk about later, their claim of purported fraud is based upon statements made outside of this agreement, and which is totally barred by the merger clause that they agreed to sign. And of course, they knew that this assignment was something that they already had a pre-existing legal obligation to cooperate with. We could have signed the document ourselves since, or at least Dr. Maida could have, because of her rights under the security agreement.
Excuse me, let's go back to the premises for that document, shall we?
Yes, sir.
We go to first page. We set out the point of this thing, okay?
The first page of the assignment?
Yeah, let me read this, okay?
Of course.
All right, next page.
If you'd like, Your Honor, I'm not sure I have replicated a full copy of the next page. I could pull the assignment and put it on.
No, I mean, we've got it here. I just wanted to
I mean, it's essentially a pretty standard assignment document that makes it clear that the assigner owns the property. It's
well, I understand that, but your merger clause, merger clauses are great for purposes of what they relate to. This deals exclusively with the assignment of the IP, right?
Yes, sir. That it is a merger clause that says, if with respect to this particular transaction, the assignment itself, this represents the parties' agreement, and there are no separate agreements with respect to this assignment. And so, we were careful to include this clause because, as I will explain to you later, this assignment came in response to our demand that they make the assignment or else we were going to bring a lawsuit. And they said, okay, we will make the assignment. And then we said, you need to pay us the rest of the money that you owe us. And I can talk to you about that in just a minute. But they can't now, my point is that they can't now come into court after signing a merger clause and say, oh, well, but you promised us other things in exchange for the assignment.
I understand.
Because,
okay.
Yes, okay, thank you.
I'm just, I think we agree that the assignment relates to, the merger clause relates to the assignment, and that's what we're talking about. All right, go ahead.
Yes, sir, Your Honor. Yes, sir. Okay, thank you. So as I said, you know, in addition to the $42,500 that was due on September 10th of 2019, and the $225,000 that was due in October, Clarisy and RxMM also agreed to make these additional 4 payments in December and throughout this past year. And none of these payments have been made. Now, what happened is in late December, as we were continuing to discuss the possibility of entering into a non-exclusive license agreement, Clarisy did make a $225,000 payment that was for the for the October 2019 amount. But they still had not paid the $20,000 still owing from September. And then they didn't pay any of the payments due under the amended note. And so December 31, 2019 comes and goes. They fail to pay this payment. We send another notice saying, you owe us this money. Of course, then we filed this lawsuit in early March. They've never made any of these other payments that are due. So as we stand here today, and by the way, they have admitted that they did not make the December payment. Of course, by the time we filed the lawsuit, it was in mid-March. And so that was besides the $20,000 that they still owed from the forbearance agreement, this was the amount that was currently due when we filed the lawsuit. And since the filing of the lawsuit, they haven't made any of the other 3 payments. And of course, I don't think there's any contest over that. But the point for our motion for judgment on the pleadings is we have come forward with a note. They have admitted, as I just showed you in paragraph 26 of their original answer and paragraph 26 of their amended answer, that they failed to make payments under the note. So that's all we have to show for purposes of winning judgment on the pleadings. And as of today, with interest, because 12% interest is accrued since January 1 of 2020, they now owe in excess of $750,000. At the end of this presentation, I'll give you the precise calculation so that you're able to, and we can certainly propose an order should the court wishes to do so. So just very briefly, Your Honor, since I know you're very familiar with this law, having probably adjudicated many promissory note cases, the law is very clear in Georgia. The Collins case, the Havendick case, both say that in a promissory note case, all the plaintiff needs to do is give you the promissory note and make clear that it is effective. It has been executed. There is no dispute over in this case, and it has been admitted by the defendants that this promissory note was executed by Clarisy, by RxMM, and is effective. Therefore, the burden then shifts to the defendants to produce evidence or to offer some kind of viable legal theory that would create a jury issue. And as I've indicated repeatedly now, there's no dispute as to the effectiveness or enforceability of these agreements, and there's no dispute that RxMM has not made those payments. So the burden has shifted. Now, what does that mean? What has Clarisy done to address this burden? Well, the first thing that I would tell you is that they have not offered any dispute about the calculations of the amount or the interest rate, or, you know, there's no disagreement here about what payments were made when. And that's really the only factual matter that a court would ever need to address or adjudicate in a promissory note case. What a defendant cannot do in a promissory note case is simply come forward with vague, empty affirmative defenses and say, oh, well, I get to, you know, protract the proceedings because I disagree that I'm in breach, or, you know, the bank did was acted in bad faith during the forbearance negotiations. Court after court has rejected those arguments, and the Court of Appeals in the rolling pin case made clear that affirmative defenses are simply not even available to defendants if there are undisputed facts that entitle the movement to judgment as the matter of law. And in that case, a grant of judgment on the pleadings was entered in a similar context. So what the defendants have done instead is generate or manufacture counterclaims after we filed our enforcement action in an effort to distract from the very simple issue before the court. But the first thing I want to tell you, Your Honor, is that Dr. Felton, who is a equal beneficiary of the agreements at issue, is not the target of any of these counterclaims. And so, you know, before I get into the counterclaims against Dr. Maida, I want to make very clear that Dr. Felton is absolutely entitled to judgment as a matter of law today on the full amount of the notes that are owing. No counterclaims have been asserted against him, and no valid defenses have been asserted against him. So the court should grant judgment to him, irrespective of how it evaluates counterclaims. With respect to the counterclaims against Dr. Maida, however, those should also be adjudicated as a matter of law because they are meritless and non-actionable, and you can make that decision on the pleadings. So all of RxMM's counterclaims arise out of a series of discussions between my colleague, Ashley Brown, at my law firm, and representatives of RxMM in connection with our effort to enforce RxMM's yet sixth breach of the second amended note and our effort to obtain relief in connection with that note. And I'm going to walk you through why none of these so-called counterclaims are actionable and all should be dismissed. So let's walk through each of them. And this is just a you know, blueprint, if you will, of what I'm going to argue, and I'm going to try to keep this relatively quick. But you know, they brought this slew of counterclaims, as many debtors do, in efforts to you know, protract proceedings and create leverage and settlement negotiations about debts owing. And so I just have to, because they have, you know, sort of thrown it all against the wall, I'm in the unfortunate position, Judge, of having to go through each one of these claims. So the first claim that they bring is this idea that we fraudulently induced them into assigning property rights that we were already entitled to foreclose upon as a result of their default. As you know, Judge, to bring a claim of fraud, you've got to include all 5 elements. I won't go through each of them, but a false representation is made. Reasonable reliance is also an important aspect to such a claim. So what are their theories of fraud here? The first is that my colleague, Ashley Brown, defrauded RxMM by threatening to file a lawsuit. That is the first theory of fraud. The second is that we defrauded RxMM by representing that we would forbear from filing a lawsuit. That's the allegation. Third is that we defrauded RxMM by agreeing that we would grant a license. And the fourth is that we defrauded RxMM by taking the legal position that we were entitled to ownership of the IP after RxMM defaulted. All of these claims are not only meritless, Judge, but I would argue are frivolous and probably do not pass the standard of Rule 11. So the first argument, or the first theory of fraud, is based upon this idea that we sent a demand letter to RxMM and we threatened to sue when RxMM claims, I guess we really didn't intend to sue, or we weren't going to really sue. I'm not sure I even understand what the theory is. But either way, courts have dealt with this type of thing before. As you will see in our next slide, multiple Georgia courts, including the 11th Circuit, have said a threat of litigation can never give rise to tort liability. it's not a statement of fact in the first place. It's not something that can be relied upon. And it is simply an exercise of a party's legal right. And so there is just clear and unequivocal case law that a lawyer sending a letter saying, if you don't pay, I'm going to sue you, cannot be the stuff of a fraud claim. And unfortunately, we asked the plaintiffs in this, we asked the defendants in this case to withdraw this claim based upon this law, and they have so far declined to do so. The second statement that they claim is fraudulent is this idea that we would forbear from filing suit. And again, just to be clear, what we said when we said sign this assignment is we are going to file a lawsuit if you do not pay. And if you want to have further discussions with us about working out the current debt owing, the first thing you need to do is assign the IP. So there is no dispute that we have fully exercised our right to foreclose on the collateral. And what you'll see from some future emails I'll show you is that RxMM immediately agreed to do that because they did not want to be sued. They were in the middle of trying to raise capital for another raise, and they didn't want to be sued. So they said, look, you're right, you're entitled to the IP, here's the assignment. And we did forbear in filing suit. I mean, we could have filed this lawsuit back in December, but instead, we waited. We tried to work it out with them. We requested further information from them, and we ultimately didn't file the lawsuit until March. And so, the idea that a statement that we would forbear from filing a lawsuit is fraudulent, again, is not actual. It's not a statement of fact. It is not a statement on which any reasonable person could rely, since a person could file a lawsuit anytime they wish. And it's simply not an actionable claim of fraud. And of course, as I just showed you, the same letter indicates that we will reserve all other rights, remedies available to us, and this doesn't release or dispose of any other rights. Of course, we ultimately filed a lawsuit not on the basis of RxMM's failure to comply with our security rights, but instead based upon the later default that RxMM caused by having failed to make the December 31, 2019 payment. And when we realized that, once again, they're going to stop paying under now the promissory note that was due, and they had still not paid the additional $20,000 that they owed us from September, we just said, now it's time to file a lawsuit. So again, non-actionable from that perspective. Third statement, they allege that we or Dr. Maida committed fraud by falsely promising to grant RxMM a license. Now, first of all, this is not any kind of enforceable promise, but I want to talk to you about the specific timeline of this allegation. So, as you know, Judge, from the earlier email that I sent to you, it was October 31st of 2019 was the date that RxMM was obligated to pay the additional $225,000. They were already in default from having not paid the $42,500 due on September 10th. So they have been in a state of default now for over a month and a half. We then do not get the payment on October 31st. So now not only did they only pay half of the first payment, but then they missed the second payment entirely. So we sent them a demand letter on November 1, 2019, saying we're going to pursue legal action. And the only way we're not going to pursue legal action now is if you don't put us through the process of having to take possession of the IP to which we are entitled. The next day, recognizing that we were entitled to the IP, RxMM wrote a letter back to us, an email back to us, which is on your screen. And in the first paragraph of that email, RxMM agreed to give us the assignment. We accept and will comply with your offer to sign the assignment of the intellectual property rights by 5 p.m. So this is before any discussions occurred with respect to the possibility of our client agreeing to go into business again with RxMM. They accepted the assignment. They said, we'll sign it, don't sue us. And the reason they did that is because they were in the process of raising capital from shareholders, I guess. I'm speculating, but they didn't want to get sued, and they knew that we were at wit's end on this stuff. So then they go on in this email to say, but we respectfully request a license, because they want to continue to try to, I guess, use our intellectual property to eventually build this nasal strip technology. So this is a separate request now, because they've already accepted and already agreed and had a pre-existing obligation to execute the assignment. That it's a separate request to discuss a licensing agreement. So on November 4th, 2 days after that, we send an email back, my colleague Ashley Brown, after having talked to Dr. Maida, who's still, having done business with these folks for years and having some desire to want to continue to try to work this out, says, look, I am willing to sign a license, a non-exclusive license, if you pay my attorney's fees, if we draft and negotiate a licensing agreement that makes sense. And so that is what we conveyed on November 4th. But the important point here, Your Honor, is that this discussion happened after RxMM had already signed the licensing agreement, or excuse me, agreed to sign the licensing agreement, after RxMM had already agreed to sign the assignment, and in the context where RxMM had no choice because they were in default. And so the point that I'm trying to make here is that you can't predicate a claim of fraud that we promised to sign a licensing agreement on something that did not where they had already promised to deliver the assignment. They didn't promise to deliver the assignment in exchange for this. They had already promised that. They already had a pre-existing obligation to execute that assignment or cooperate with us. And there are other reasons for this as well. They don't dispute the enforceability of the security agreement. As I just said, they had a pre-existing legal obligation. They were already in default. They had been in default since September 10th, and they can't be induced to doing something they're already legally obligated to do. And the most important case that we cited in our briefs for this, Your Honor, was the Bridgers case, that you cannot commit fraud to induce a party to perform its legal obligations that it already has an obligation to do. Such a claim of fraud is non-actionable. And that really should end the inquiry on that. Now, the fourth statement, which relates to the same point here, they allege that we committed fraud by taking the legal position that RxMM was in default. And once again, for the same reasons as I've talked about, one cannot predicate a claim of fraud on another party's legal position, its opinion about the meaning of documents. And just to add to the law on this, the Cotton States case that we cite, Hamilton, all say that you can't predicate a claim of fraud on one party's interpretation of a document to which both parties have equal access. RxMM is a party to all of these documents as well. If they disagree with our interpretation about whether they're in default, well, they can explain that in a court of law and we can debate it. But just because we take a position that they disagree with doesn't make it fraud. And we, of course, are asking you today to rule not only is our position not fraudulent, but because of the facts that RxMM has admitted, the fact that they didn't make the payment due on September 3rd, the fact that they didn't, or 10th, the fact that they didn't make the remainder of the payments due under the note, they were in default as a matter of law. I spent the most time on that claim, Your Honor, because I think that really is the entire substance of their effort here to, protract this case. Everything else really falls if you reject their effort to manufacture a fraud claim. Negligent misrepresentation predicated on the same facts. This is another counterclaim they bring, but it also fails for the additional reason that, we have no duty under Georgia law to them to represent to them the rights that they have or don't have under a particular set of agreements that we have. And we've cited multiple cases, and you can imagine the chaos that would ensue if every time a debtor disagreed with a lender over a lender's position about legal documents that they could bring a negligent misrepresentation claim. It simply doesn't work. And also a law firm representing an opposing party owes no duty to, accurately state the law, even though we did, to an opposing party. And that's essentially what that claim is predicated on. The RxMM also brings a claim for rescission, but rescission is only appropriate first and foremost where there is a actual fraud. And so if the fraud claim fails, then so does the rescission claim. We've cited the Champion case for that. And in addition, rescission must be timely. And we've cited numerous cases for this. As the Buckley case held, an announcement of the intent to rescind a contract must be made in a timely fashion as soon as the facts supporting the claim for rescission are discovered. Courts are quick to find rescission has been waived. This is the Conway case. The defendants did not come to you and complain that we had defrauded them into signing this assignment back in November of 2019. They didn't bring this claim until after we sued them in March. And of course, they didn't bring this preliminary injunction motion until just a few weeks before, we are going to file this motion for judgment on the pleadings. So this isn't even close to timely. The request for rescission reeks of yet another strategy that is designed to just complicate what is otherwise a very simple and straightforward note case. Claim for rescission fails as untimely as a matter of law. RxMM has also brought what I would certainly consider a frivolous tortious interference claim because it's so obviously barred by what is now litany of Georgia case law on the stranger doctrine. RxMM claims that somehow Dr. Maida, by simply exercising her rights as a creditor, tortiously interfered with some effort by RxMM to raise capital. As a creditor, Dr. Maida, Dr. Felton are not strangers to any transaction. They are also shareholders of Clarity, seeking to enforce their original rights under the shareholder agreement where they agreed to sell, their company and their intellectual property. They have a legitimate interest in the contracts at issue. They certainly, if the company were to be successful, they would benefit not only in the form of being paid their debt, but as shareholders in the underlying company. So they're clearly not strangers to Clarity and RxMM's efforts to raise capital, whatever those may be. Finally, the breach of contract claim is predicated on a single email in which, as I showed you earlier, we indicated an openness to renegotiating a licensing agreement. But that breach of contract claim fails because there is no enforceable contract here. There is simply at best, an agreement to agree, but an indication that we would consider a licensing agreement upon the condition of certain future events happening. Of course, the licensing agreement itself did not include material terms, including the term of the agreement or the price, and cannot be enforced as a result. We've cited numerous cases that require that. If there is no firm agreement as to the price, a contract is unenforceable. There would be no way, Your Honor, for you to fashion a remedy for a non-exclusive license of an indefinite term for an indefinite price based upon a single email that itself had conditions and reservation of rights. So this idea of a breach of contract should be dismissed based upon the absence of any material terms and as an unenforceable agreement to agree. Finally, Your Honor, I said finally before, but I think this is the last of the counterclaims. The defendants also bring equitable claims, and we would just argue that standalone equitable claims here must fail as a result of the defendant's unclean hands. He has, who would have equity, must do equity. And we have cited cases where debtors cannot bring vague claims of equity as a means of protracting a simple note case and avoiding a clear, unequivocal, unambiguous debt obligation. I'm sorry, one other claim. The defendants also bring a claim for...
Finally?
Finally. Yeah, this is the lawyers finally. The defendants also bring a claim for declaratory relief, but there's no action that they are uncertain about that they need, Judge, your guidance about. I mean, this case is entirely about events that have occurred in the past, whether Clarity and RxMM owe Dr. Felt and Dr. Maida money. And, you know, if there were some dispute about the assignment, then, you know, you would be deciding on what the legal effect is of the actions which have already happened. So again, a declaratory judgment would not be appropriate here because RxMM is not requesting that you give them guidance on some uncertain event in the future that they are waiting for your guidance to take. This is just a throwaway declaratory judgment claim that seeks a academic ruling about past events. So just to summarize, Your Honor, we would ask that you enter judgment on Dr. Maida, Dr. Felton's claims under the promissory note, and that you dismiss the counterclaims that have been brought by RxMM and Clarity. And I want to end by just pointing out once again, not a single dollar has been paid on this note that is at issue. There's no dispute as to its enforceability, as to the fact that it was executed. And the amount due under the note is now $748,771.83. We have calculated that amount based upon the principal amount owing plus interest of 7% until the breach on December 31 of 2019, 12% after that breach. That 12% continues on a per diem basis, and we're certainly glad to provide the court with the calculation, or if the court wants to enter judgment on the claim and then have us submit our calculation to provide the defendants an opportunity to challenge it in any way, we would be glad to do it in that way as well. You know, in other note cases that I've brought, that's been, the court has asked me to either propose an order and provide the opportunity for the defendant to comment, or it has entered judgment on the breach of contract claim itself and then invited the parties to then submit evidence of the calculation of damage. Whatever the court would prefer, we would be certainly happy to assist with. The final point, the fifth final point that I want to make to wrap this up, Your Honor, and just to preview, I've got some other things to say about the preliminary injunction motion, but I would suggest that we wait for that until we complete argument on the motion for judgment on the pleadings. But, you know, what would be remarkable today is if a creditor who has security and who, I mean, the entire theory of RxMM's case is they want the security back. They want the IP back that they agreed to pledge in support of their promise to pay the note. They have not paid a single payment on the note. And so the idea that the security should somehow come back to them is so ridiculous, because even if we couldn't have taken assignment of the security on December 4th, which they voluntarily gave us, we would have been able to take it on September 13th when they first defaulted, or any time since December 31, 2019, when they defaulted under the promissory note. So I would conclude by just observing the reality that, you know, whatever the debate over the assignment on December 4th, I mean, just today, as a result of the defendant's continuing default, we could take the security and, and dispose of it as the security agreement provides. Unless Your Honor has any questions, that would conclude my presentation, and I do appreciate the liberal amount of time that you've given me.
Well, they made a payment in December of 19, yeah?
That is correct. They made a single payment in December of 19.
But what was that for? What did that represent?
So in the court, that was for the payment that was owing on September 30th of 2019 under the forbearance agreement. And if you'll give me a second, I'll bring you back to those.
Well, let's just hold on.
Okay.
So the payment due under the forbearance agreement, what was that due for? You've represented several times now they haven't made any payments on the note, but the original note was $900,000, and today you're only suing for less than it.
Right, because that is correct. They have made some payments. I mean, they basically.
No. You said they made no payments, not a penny.
That's correct. Okay, I'm
sorry.
sorry.
How did it get from $900,000 to $750,000 if they made no payments?
That's a fair question, Your Honor.
A fair question. I like to ask those.
So first of all, we started this enterprise with them owing $900,000. When we entered the first forbearance agreement, they made, they missed their first payment, but if my recollection is correct, they may have made a payment on the first forbearance agreement that was late, that then gave us enough hope to then agree to the second forbearance agreement and note.
The amount paid on the first forbearance agreement, what did
it was a small.
Listen to me. Was it was the number that was applied against the balance due on the note? Whatever they paid, you know, the note was $900,000. You said they haven't made any payments on the note. The note isn't $900,000 anymore. How did it get down to $750,000?
That's fair, Your Honor. So
again,
let me try to explain it, and I can, if it's easier.
I want you to explain your statement that they haven't made any payments on the note.
Right. So
why did you say that if the balance on the note is not the same as it was when it was written?
That's correct. So this is the note that I'm talking about. It is the amended and restated negotiable note that was signed on September of 2019. Now, as of this point in time, Clarity had made a few small payments towards the original note, and then we entered into a new forbearance agreement that said, at a time when they owed about almost still $900,000. And in that second forbearance agreement, we changed the note. The note was for $655,000 because the second forbearance agreement, and now I'm flipping you to that page of the second forbearance agreement, assumed that they would have paid these two payments before the note then took effect. And so when we sat back down and all agreed in September of 2019 what their payment schedule would look like, these were the three payments that were left to be made. And really, since the note contemplates four payments, there were a total of six that would be due under the global deal. And so, as I said, we came back together. We said the only way we are going to agree to yet again enter another creditor-debtor relationship is if we get security this time. So we got security in the form of the IP. And then we said, a week later, you owe us $42.5. By October 31, you owe us $225. And then this note will take effect. And so to be clear, under Section 4.8, they made a $20,000 payment towards that amount. Now, $17,500 of that is attorney's fees. So they get $2,500 in credit for that towards the balance, which we have included. And then on October 31, they failed to make the $225,000 payment. That is when we made our demand to take the IP. They gave us the IP. And then over the course of the next several weeks, we negotiated with them further about the possibility of entering into another kind of licensing agreement. And they did make a payment in December of 2019 of $225,000. So we are not seeking recovery.
It was really 226,000, wasn't it?
Well, it was yes, sir. It was 226,500, 1,500 of which was attorney's fees.
Okay. And the 225 was one of the payments due under the
forbearance agreement. That's right. And so they did make that payment. Of course, it was made about a month and a half late. But so you're right that they have made some payments, but under the forbearance agreement, they still owe us $22,500 because they failed to make a full payment for the Section 4.8 amount. And then, as I said, Your Honor, the amended promissory note required that they make a total of about $650,000 payments, and they haven't made a single payment towards that. That's what led to this lawsuit being filed, because December 31 came and went, and they didn't pay that 163. And then we said, we've had enough. And so I'm sorry that I wasn't clear, but it is an accurate statement to say that they have not made a single payment towards this amended promissory note.
All right. Okay. You could take your screen down, and Ms. Watts, you're up.
Yes, sir. I'm going to do that. I just figure out how to do that. Okay.
Your Honor, at the outset, I just want the record to be clear. There is nothing about the $42,500 payment that was due in September of 2019 in the pleadings, which is what this motion is before the court on, a motion for judgment on the pleadings. That's not anywhere in the complaint as far as I recall. And in fact, we vigorously dispute that there has not been, that payment wasn't made. My records show that a payment of $20,000 was made on September 10th of 2019, and the remaining balance of $22,500 was made on the 20th of that month within the 30-day cure period. So setting aside the fact that that's not even in the pleadings for the court to rule on, we contend that that payment was made. In addition, the October 31st, 2019 payment was made within the 30-day cure period, which got extended because it fell on a weekend, and the agreement provides if it falls on a weekend, it gets extended to the next business day, which was December 2nd, and that's when that payment was made. So I just want the record to be clear on that. Your Honor, I think there's some additional information that the court should be aware of in deciding this motion. Our client, RxMM Health Limited, is an Australian company that invests in and markets and distributes medical technology. Dr. Maida developed a medical product, a patented nasal strip, capable of delivering medicine and supplements to the human body. RxMM learned about this product and thought it might be a suitable device for delivering medical marijuana and cannabis. And after discussions with Dr. Maida, wherein she represented that the nasal strip would in fact be suitable for this use, RxMM offered to license the technology from Dr. Maida. In response, Dr. Maida offered to sell her company, Clarisy, to RxMM for just over $1 million, almost the same price that RxMM had asked to license the technology for. And at the time of the sale, Clarisy was deeply in debt. The plaintiffs had mortgaged their own house to loan $900,000 to the company. And this is the $900,000 that becomes the issue. That's the debt that is the focus of these notes. And RxMM assumed this debt as part of the sale. And there's not any dispute that the sole asset of Clarisy was not that this product was in the market generating money at the time of the purchase, but that the sole asset was the intellectual property for the nasal strip, which had not been successfully marketed or sold at that time. After the sale closed, despite Mr. Kaplan's claim that my clients did nothing with this intellectual property, they did in fact attempt to market the product and manufacture the product in a way to deliver medical marijuana and cannabis, but learned, despite the representations that were made, that it could be used for this purpose, that it couldn't. And they were now faced with having a product on their hands that wasn't fit for the intended purpose of the purchase. And because of this, my clients understandably had a difficult time generating money to make the payments. But instead of walking away from the deal and not making the payments, they attempted to come up with a plan to successfully market the nasal strip for a different purpose, the one that Dr. Maida had originally intended for plant-based solutions and things of that nature. And contrary to the claims today, my client, RxMM, has paid almost a little bit over $1 million for this intellectual property, approximately $400,000 as a cash portion of the purchase price, $71,000 paid to other Clarisy shareholders at the time of purchase, $160,000 to Clarisy's creditors at acquisition, almost $100,000 to Dr. Maida for consulting fees, and then $272,800 under the parties' later agreements. So there have been payments made. And yes, Mr. Kaplan is accurate that under the amendment to the forbearance agreement that there haven't been payments made, but there have been significant payments made by my clients for this intellectual property that is now no longer in their hands, despite the fact that they are now being asked to continue making payments. This case is really about what happened in a short window of time between November 1st, 2019 and November 4th, 2019. And Clarisy CEO, Mr. Lyndon James, is here today to testify about what happened in that time frame if we need to get to that. But what the allegations in the verified counterclaims state is that our client, and what Mr. Lyndon James will testify to in connection with the motion for injunctive relief, is that Clarisy was attempting to figure out a way to regroup once they couldn't use the nasal strip for the intended purpose. They knew they owed money. And so our clients connected with a company called Global Investment Capital Corporation. They executed a letter of intent in early October of 2019 to conduct a reverse mortgage, whereby Clarisy would take control of Global and Global would retain an equity in the company. The objective of this was to have a vehicle to conduct a secondary capital raise to properly capitalize Clarisy for the purpose of marketing and manufacturing the nasal strip for the purpose that Dr. Maida originally intended. But they needed to properly capitalize the company with the right team. And Mr. Lyndon James will testify that when he and Clarisy CFO, Geza Molnar, were preparing to travel to Toronto on November the 3rd, which is the Tuesday in this window, for a very critical meeting related to this merger. And they knew that to go into this meeting, they had to have the right to use the intellectual property. And the plaintiffs knew about this. They knew about the merger, and they knew that our clients were trying to raise capital in order to complete this merger and indirectly pay back the plaintiffs. So as Mr. Lyndon James and Mr. Molnar were preparing for this very important business meeting in Toronto, they were not so concerned when they received the notice of default that the plaintiff's attorney sent on November 1st, earlier in the day, that said, you have not made the October 31st payment, which was no surprise to anyone, and that there's a 30-day cure period for you to make this payment. And if you don't make the payment within that time, then we're prepared to move forward with claims against you. What raised the hair on the back of their neck was the email that came from the plaintiff's counsel several hours later on November 1st, which was the Friday, stating that actually the plaintiffs were prepared to immediately file suit against our clients, and not just our clients, but their principals and their related entities for breach of contract and fraud if they did not immediately assign the intellectual property back to the plaintiffs within 2 business days, by Tuesday at 5 p.m. And we can look at those emails. I'll share my screen. I think Mr. Kaplan has already highlighted them, but I would like to go ahead and put these on the screen. We have the first, this was the notice of default. And Mr. Kaplan's argument that there was no 30-day cure period, I think is belied by both the language of the amended and restated negotiable promissory note. Section 6.3, which provides 30-day window, doesn't just say the covenants. It says any obligation under this agreement. If you fail to meet any obligation under this agreement, that it will become an event of default after the failure continues for 30 days. And that the plaintiffs recognize this is shown by this very letter, where it says that under the note, the specified default shall become a capital E event of capital D default under the A&R note. And these terms are important because this is the same language in the security agreement. It defines an event of default, entitling Dr. Maida to the intellectual property as the definition in this agreement. And so an event of default does not occur until the elapse of 30 days as required in section 6.3. This is their own words. This is their clear understanding that this agreement provides for a 30-day cure period for each of the payments in the agreement. And they go on to say that if the past due amount plus the additional $1,500 for the legal fees is not paid by November 30th, which was on the weekend, so that date moved to December the 2nd, then they will intend to exercise their rights. But this letter in itself acknowledges the 30-day cure period. It provides for the 30-day cure period, even if they want to dispute that the amended and restated note does not provide for it. They provided for it in this very note. And then we have the email. This is 4 hours later, that despite that letter, that they're prepared to file a lawsuit against the clients, their related entities, their principals for fraud and breach of contract, and that they are willing to consider not immediately proceeding with the litigation on one condition: to execute the assignment. They further state that given the defaults, there should be no dispute that Dr. Maida is entitled to the patent rights under the security agreement. And they demand that they assign the intellectual property as a condition to discussing the forbearance. This offer will expire at 5 p.m. on Tuesday, November the 5th, the day that my clients were supposed to be in a meeting representing that they had access to this intellectual property and to continue with their merger. And so we have an email the next day on Saturday from the CFO of Clarity, Geza Molnar, informing them, as if they already didn't know, that this intellectual property is the critical asset for the merger and that they need access to this intellectual property, and asking for recognition of the deferment period. And in response to that, we have an email at 2:50 that day from Dr. Maida's counsel, basically saying, we have concerns about your merger and the deadline remains. Our offer to sign the IP assignment remains for 5 p.m. on Tuesday. And so in the face of that, We have Mr. Molnar responding several hours later saying, we will accept this. However, and this is where we will have testimony from Mr. Lyndon James and Mr. Molnar, obviously not today, but Mr. Lyndon James is certainly here to testify that they would have never signed the assignment without the license. Why would they? There is no incentive whatsoever for my clients to sign an assignment handing over the intellectual property without something in return, either forgiveness of the debt or a license. And so this email written by not an attorney, but by a businessman says, we'll do it, but we're going to need a license if you want us to do it. And in response, if there was any confusion as to whether there was an acceptance, plaintiff's counsel's email on Monday morning at 6 a.m. confirms that they understood that this was not one without the other. Contingent upon execution of the assignment, our clients are willing to grant Clarity a non-exclusive license for Clarity to use the intellectual property. If you accept this offer, we will calculate our client's actual and anticipated fees and provide that figure to you. And in response, Mr. Molnar responds Monday, the day before their critical meeting, knowing they needed to have this intellectual property to go into this meeting. Ashley attaches the executed assignment of IP rights. And then we have just 9 days later, we have an email from Dr. Maida's counsel, plaintiff's counsel saying, we previously stated that they would consider granting the license, but that offer is hereby withdrawn. And then we have later communications. This is on the 27th. The payment still hasn't been made. We're within the cure period. And it says, here's a recognition that they knew that the time to cure was 30 days. As you know, the period for RxMM and Clarity to cure their most recent default expires at the end of this month. We await payment by Monday, December the 2nd, and we will not entertain any further discussions regarding the license of the IP until a substantial payment is made. Once the cure deadline has elapsed, and unless we receive payment, we plan to proceed with filing a lawsuit. Very different language from the email on the first saying, we're prepared to immediately proceed with this lawsuit unless you assign us this IP by November 5th. So, as we prepare for this very important meeting, we have these emails, and Mr. Lyndon James will testify that he and Mr. Molnar were under duress when they received these emails, knowing that their last-ditch attempt to save Clarity and that the global merger hinged on their ability to have a right to use the IP. And Mr. Lyndon James will testify that he was in constant communication with Mr. Molnar and that they both understood that email from Mr. Molnar saying that they would sign the assignment if they got a license back to be one with the other. It wouldn't have happened without the license. And again, why would they have any reason to execute the assignment without getting anything in return? And this is what is before the court today. For our motion for injunctive relief, we have our client prepared to testify that, but it also relates to the claims in the verified complaint from our clients that support the counterclaims. At the end of the day, even if you believe that nothing wrong has happened here, which is an incredible position given these emails, the plaintiffs got the intellectual property back, intellectual property that our clients had paid more than $1 million for. And because of this, the essential element of breach of contract of showing damages is missing because the plaintiffs actually got a windfall out of this. But now they're asking for my clients to continue making payments on an asset that's in their possession. Specifically related to their breach of contract claim, they have to show on a motion for judgment on the pleadings that the undisputed facts entitle them to this judgment. Similarly, under OCG 113308, that provides that a holder of a negotiable instrument is not entitled to judgment where the defendant proves a defense or a claim in recoupment. Obviously, we're at the pleading stage, Your Honor. That's what you have in front of you. And in our pleadings, our clients have asserted 14 affirmative defenses and have denied any obligation to make these additional payments after the November 1st, after the fraud that was committed. They had no more obligation to make payments. Why would they continue to make payments under an agreement when the asset was back in the plaintiff's hands? How could there be any obligation to keep making payments? And there's 14 affirmative defenses that refute any obligation to do so. In addition, there's also a flat denial of any obligation to make these payments, which means on the pleadings, judgment cannot be granted. There's also a denial of damages, as I already explained. They were basically oversecured creditors. They got the intellectual property back. They have no damages here. And we have 14 other affirmative defenses that we are entitled to put on a claim for. In addition, I'll go ahead and address the merger clause here in the assignment, Your Honor. Obviously, we brought a claim for rescission, which means that the agreement would be rescinded and a merger clause would not apply to that. In addition, it's limited to the subject matter of the contract. It doesn't extend to other subject matters, and merger clauses prevent claims that contradict the written contract, not claims that are outside the scope of the contract or relate to another matter. Our claim is for the license, and that's in Legacy Academy versus Mammy Love, 297 Georgia 15, 2015. And again, it's also the merger clause is unenforceable given the fraud claims and the rescission claims. Ultimately, the affirmative defenses, our client is entitled to conduct discovery and present evidence to the court on all of these defenses. And I'll pick out a couple of them. Accord and satisfaction. When you get the intellectual property back, there's an argument that any obligation to pay has now been satisfied. There's also an estoppel claim, which is generally a question of fact for the jury to resolve. And we cite cases in our brief that covers all of this. Most of these defenses involve questions of fact for a jury. There's economic duress, where an undue or unjust advantage of a person's economic necessity to distress him or coerce him into making a contract is a defense. That's Hampton Island versus HAOP 306 Georgia App 542. That's exactly what happened here. The plaintiffs knew of our client's position. They knew that they were trying to get this merger deal done and took advantage of it, knowing that they would probably do anything to go into these meetings, knowing that they needed access to the intellectual property. There's also an impossibility of performance defense. This is OCGA 13423. If the non-performance of a party to a contract is caused by the conduct of the other party, that conduct shall excuse the other party from performance. And in the case we cite in our brief, Taliforo versus Rose, 220 Georgia App 249, the court found that's a question of fact for the jury to resolve. There's also failure of consideration. The very point of all of these agreements was the intellectual property. If that's no longer in my client's possession, there's a failure of consideration under these agreements. Given the defendant's assertion of these defendants, it's reversible error for the court to grant the motion for judgment on the pleadings. And that's Person versus Dealer Service Plan, 141 Georgia App 148, which reversed a grant of motion for judgment on the pleadings, where the defendant admitted execution of a note, but pled affirmative defenses, just like my clients have done here. And that's also supported by the Freezomatic Corp case versus Brigadier Industries that we cite. That's 125 Georgia App 767. That affirmed a grant of a motion for judgment on the pleadings where the defendant failed to plead an affirmative defense, which is not what's happened here. And the affirmative defenses would apply equally, even though there's no counterclaims against Dr. Felton. The affirmative defenses would apply equally to him. Fraud would apply equally to him. It was his counsel that was making these representations. And any amount of set off that must be accounted for here would also apply to his claim as well. It's a joint claim of the two plaintiffs. A claim of set off pertaining to one would apply to the other. I'll now address the defendant's counterclaims, and I'll remind the court that it's an incredibly high standard here. This is basically a 12B6 standard where it must appear to a certainty that the defendants could not possibly introduce any evidence within the framework of their claims sufficient to warrant the grant of relief. I think we've already gone through the emails, and I'll reiterate the point about the cure period, because I think this really wasn't something that I saw in the briefing, but I want to make it clear that Section 6 of the amended and restated negotiable promissory note provides for the 30-day cure period. The obligation under this note was to make payments. What other obligations were there? So 6.3 that says that when you fail to observe any obligation other than specified in section 5.1, then that failure continues for 30 days, that becomes an event of default. Unless there be any confusion, their own notice of default confirms this. It confirms that there was a 30-day cure period to make these payments, which again, I will also reiterate that we dispute that the $42,500 payment that was supposed to be made by October or September 31st was not paid. My clients made those payments within the cure period and also made the October 31st payment within the cure period. Now, they are trying to prove based on the pleadings that there's no fraud here. But as we cite in our brief, proof of fraud is rarely susceptible to direct proof, and recourse to circumstantial evidence is often required. These statements were, in fact, false. Her theory is it's not just a threat of litigation. It's not just saying, we're going to sue you if you don't do this. It's threatening litigation when the plaintiffs knew they were in no position to do so. And that's the definition of fraud. A misrepresentation can be to a future event where the promisor knows at the time of the misrepresentation that the event will not take place. That's Greenwald versus Odom, 314 Georgia App 46. That's exactly what happened here. They threatened legal action on November the 1st, knowing full well that they couldn't immediately file the lawsuit if the assignment didn't occur. Their rights to do that would not have accrued unless my clients didn't make the payment within the cure period, which they did. There's no dispute that they did make that payment within the cure period. So the rights under any right to file a lawsuit was not ripe when it was threatened. And for this same reason, the security agreement, which defines the event of default the same way that the amended and restated note does, the security interest had not been triggered because the 30-day cure period had not elapsed. My clients made the payment within the 30-day cure period. So on November 1st, when the email comes through, these statements are in fact misstatements. And it's not just a misstatement of law. It's a misstatement of my understanding of my rights are that I'm entitled to this intellectual property under the security agreement. And I'm going to sue you if you don't immediately assign this intellectual property back to me. That is fraud because they had no right to do so. The security agreement had not yet been triggered. In addition, with regard to the license, there was no obligation, again, to assign the intellectual property as of November 1st. That actually never occurred. And what the purpose of the security agreement was to give the plaintiffs a remedy if my clients didn't make the payment. They were oversecured creditors at that point, having the whole purpose of this transaction, the intellectual property, was now the basis of a security agreement. Despite my clients paying over $1 million for this asset, that was on the line if the payments weren't made. And under the text of the offer for the license was clear. It's not we're going to sign the assignment, and we need a license. It was, we will sign the assignment, and however, we need a license. And again, if there's any confusion about what my clients intended or how it was received by the plaintiffs, the following email saying, if you execute the license, my client will give you, or if you execute the assignment, my client will give you the license. That is clear. If you accept this offer, that is the language in the email. There's no confusion that our clients were not accepting without the other. It was both together. They never would have agreed to assign the intellectual property without getting something back in return. The bottom line is whether these statements constitute fraud is a question of fact for a jury to resolve. This certainly cannot be resolved on a motion for judgment on the pleadings. With regard to the negligent misrepresentation claim, the same elements apply. And here, it's not a question of whether Dr. Maida's counsel owed a duty to our clients, but it's whether she owed a duty, whether the plaintiffs owed a duty to my clients in their communications during this time period. And there is an implied duty of good faith and fair dealing in every contract. And this duty extends to acting in good faith with the defendants. And with regard to the statements in the emails, these were statements about these agreements. These were statements about the parties' rights under these agreements. And this duty of good faith would further apply to any email sent by the plaintiff's counsel. And the rescission claim, here again, we're talking about a question of reasonableness of the time of the rescission. And it's not about when the actual alleged fraudulent event occurred here. Yes, the fraudulent statement of we will give you a license if you execute the assignment occurred back in November of last year, but there was continued negotiation between the parties from November until my clients hired this law firm in January. And we continued this conversation through the end of February of this year. And it wasn't until the lawsuit was filed and my clients received service of the lawsuit, which is the first that we even learned of the lawsuit, that we knew that, in fact, there wasn't really any hope of actually getting the plaintiffs to make good on this promise of a license. So there's definitely the timeline here, the cases they cite for finding as a matter of law that the rescission was untimely. None of the cases support even their 5-month window. If you take from November to April, which is when the rescission was sent, it's a less than 5-month window. No, I guess yes, it's a less than 5-month window. That's right. None of the cases say as a matter of law that you can decide on a motion for judgment on the pleadings that the rescission was untimely. The cases we cite, Mitchell versus Backus Cadillac Pontiac, that's 274 Georgia App 330, says that a question of what is reasonable or proper time within which to rescind a contract depends on the facts of the particular case and is ordinarily a question for the jury. And we will further contend that the fraud did not become discoverable and fully apparent to us until well into 2020 when the lawsuit was filed and we realized that there was no hope in actually getting the license. The tortious interference with business relation claim, their main defense of this is the stranger doctrine. And what they failed to reckon with is the case we cite in our brief. This is the Howerton versus Harbin Clinic case, 333, Georgia App 191. And it says that to be an unintended third-party beneficiary of a business relation, sufficient to prevent a party from being a stranger, requires that the party have a legitimate and direct economic interest in the business relationship at issue, but that a party does not become an unintended third-party beneficiary of a contract or a business relationship simply because they might receive an incidental benefit from the relationship. Here, they try to argue that the plaintiffs were going to get money if this merger went through, and so they had enough of a relationship. That is exactly the incidental relationship that is not sufficient to make this stranger defense apply. And we also cite cases in our brief that this is further a question of fact that can't be resolved on the pleadings. It can't be resolved from the text of the pleadings before the court, whether there is a sufficient interest in this business relationship such that this doctrine would apply. On the breach of contract claim, we've already addressed the argument that Mr. Molnar's November 2nd, 2019 email was an acceptance. The clear text of the email shows that he was indicating a willingness to execute the assignment. Acceptance would have been sending it back, which he didn't do until the next email came in saying, if you execute the assignment, we will give you the license. If you accept this offer, we will calculate the attorney's fees that we're asking you to pay. That language is very clear. And there can't be any confusion on that my clients never would have signed the assignment without the license. That would have doomed everything for them that they had been working for with this merger. They also say that there's no terms, but the key terms are there. The key terms in that email are, if you accept, that's the consideration. You sign the assignment, we'll give you a non-exclusive license that has no duration. That's a clear reading of that email. Those are the key terms. What's the consideration? It's non-exclusive and it's unlimited in duration. While there may have been some, discussion after that about negligible terms, those are the key terms in that very email. In addition, the cases that they rely on for summary judgment on this issue are all cases on a motion for summary judgment, where the court's able to weigh evidence about what the terms of the contract were. This is also an inappropriate issue for the court to resolve on a motion for judgment on the pleadings. With regard to the equitable relief, their main argument is that the court is supposed to consider my client's inability to make payments for a product that they purchased that didn't work as it was intended to, or that they were told that it would work. That's not a defense to these claims, because the parties then entered into forbearance agreements and they entered into subsequent agreements, and my clients made good on their end. Under the last forbearance agreement, they made the September payment, and then they put together the $225,000 payment, despite the fact that the IP was now in the plaintiff's hands. They still made the payment because they were told, make the payment and we'll talk about the license that we already promised to you. If anything, my clients are certainly entitled to equitable relief, given that they've done what they were supposed to do under that agreement and have technically assigned away a right that they had no obligation to and received absolutely nothing in return for. The final claims for declaratory judgment, I will add at the outset that RxMM has a separate claim for declaratory judgment related to a license agreement that Clarity and RxMM entered into shortly after the sale of the agreement. And that claim has not been addressed in their motion for judgment on the pleadings. And that basically is, there's a question about whether that license is now, if the plaintiffs are in fact the owners of the intellectual property, there is a question. Our position is that license would transfer to them, that they are now the new licensor, and that RxMM has rights in the intellectual property under that agreement. We have put that position forward to the plaintiffs. They have responded saying that they do not believe that that license agreement has any effect, that it did not carry over. RxMM is uncertain as to what its rights are under that license and is asking the court to declare what those rights are. In addition, there's also a claim for declaratory judgment that the assignment is void for two reasons, based on a lack of consideration. If in fact this was a fair deal and our clients assigned away the intellectual property and are not entitled to a license and are not entitled to forgiveness of the debt, then they received absolutely nothing for that assignment. Absolutely nothing, something that they did not have to do. There was no obligation to give that. And so they're uncertain because they've sent a claim for, or a notice of rescission. We sent a notice rescinding the agreement back in April, and the plaintiffs responded saying that they rejected our notice of rescission. There is uncertainty. There's a patent application that's currently being prosecuted as part of this intellectual property. My clients don't know what's going on with that. They don't know if they have obligations to pursue any of that. And they certainly have uncertainty in the case we cite in our brief, the Radio Perry Inc. versus Cox Communications case, 323 Georgia App 604, says that a declaratory judgment is appropriate in a case where a party rescinds a contract and seeks a declaration that the contract was rescinded. And then one other point that I wanted to make about the collateral under the security agreement, their right to the collateral was executable through a legal process, to a foreclosure process that's set forth in the UCC. And that process includes giving notice to my clients that they were going to foreclose on the asset, a public sale or other remedies to execute the foreclosure, and then a credit and a return of any excess proceeds to the debtor. So akin to a foreclosure on a house. If there's extra money that the bank has been given that goes beyond what the house is sold for, that debtor is entitled to a refund of that money. Their remedy is not to an immediate assignment without any offset of the debt. And I will reiterate our point that there is nothing that I have seen in the IP assignment agreement that says that my clients had any obligation, even if there was a default, to assign the intellectual property back. I've read the sections they cite. We cover this in our reply brief. There's nothing in there that required them to do that. The fact that they forced the assignment through fraudulent and false statements makes their conduct particularly egregious here. And I think that covers everything.
Let me ask you, are you claiming damages? Do you think that you're, as a result of your claims, you're owed money?
I certainly think my clients are claiming damages in that on several levels. They've paid for an asset that they now no longer have. They've put over $1 million into paying for intellectual property that is now allegedly back in the plaintiff's possession. There's damage on that level. There's also punitive damages and attorney's fees that are recoverable with a fraud claim. And then there's damages from the fact that this merger deal was set to go forward and my clients had to back away from it because they were told they would get a license and then they weren't given one. And so without the intellectual property, they weren't able to go forward and proceed with the merger deal. So yes, there are damages in this lawsuit.
Now, it seems to me that the claim that you have is for the $226,500. As far as the merger claim, again, that's a claim, like you say, a lot of these things, a lot of your counterclaims, most of them, maybe all of them, are fact-intensive issues. Present fact-intensive issues that have to be resolved. For example, like the merger, you feel like that's a viable claim, that you are going to be in a position to actually present evidence to show that this merger would have occurred but for something? Is that what you're saying?
Yes, Your Honor, we have a signed letter of intent. We have press releases that went out. I mean, there's a clear showing that this merger was fully prepared to go forward. Our clients were moving. They had the letter of intent. They have there's press releases related to it. Yes, I think that that's a viable claim. I think that we are prepared to show that that merger was going to move forward. And our clients, like I said, they had to back away from it because they didn't have access to the intellectual property anymore. That's the very foundation of the merger.
Tell me, what is the impact of the failure of your client to make payments or do things that were required under the various agreements? How does that affect the case?
I'm not sure which.
Well, it was a forbearance. Why was a forbearance agreement necessary?
Because they were struggling to make payments. They bought the product, they bought the company for the intended purpose of using it for medical marijuana, and were represented that this would be a product that could deliver such a substance. And then they discovered through, manufacturing and attempting to make it come to fruition, they discovered that they couldn't actually use it for that purpose. And so they basically had an asset that they purchased that wasn't fit for the intended purpose. So they did have trouble making these payments. And the company, they bought a company that was in debt. It's not like they bought a company that was doing well and they somehow, mishandled that.
Well, that's not the seller's fault. As the buyer in that transaction, you buy what you buy, and then you pay for it. The fact that you don't think maybe you overpaid, or you didn't get what you thought you were going to get, or it didn't work the way you wanted it to work, that doesn't excuse you from paying for it, right?
You're correct, Your Honor. And that's why our clients move forward with trying to find a different avenue to use this intellectual property. They found this merger deal. They were prepared to capitalize the company and try to use the product for the original intended purpose. And they were trying to do that. That's exactly what they were trying to do here.
All right. Okay. All right, Ms. Kaplan, is there anything you want to say in response to what you've heard? Just rebuttal?
Yeah. Yes, Your Honor, I would like to have a brief rebuttal. Thank you for the opportunity.
Now, I know, unlike the use of the word final, you did say brief, so let's keep it brief. Go ahead.
I'll do my best, Your Honor. There's a lot to respond to, but I will try to keep it to the subject at hand and the issues at hand. So the first point that I want to make, Your Honor, is that we are before you on a motion for judgment on the pleadings. And I would suggest that conservatively, I would estimate that 75% of what was said to you in the last argument was not in the pleadings at all, that it was outside of the pleadings. And that on a promissory note case, your scope of review is limited. There is no dispute, and you heard no dispute as to the validity of the note at issue. You heard no dispute that the note hasn't been paid. Now, one thing you did hear today, which I don't think was in the briefing, was that there should be some credit for the intellectual property that has been foreclosed upon in effect. And one reasonable way to address that issue would be to enter judgment, because there is no question that RxMM and Clarity are obligated under this note, but then to have a proceeding to address damages. Our view is that the intellectual property that we obtained is virtually worthless because it expired. RxMM did not invest any capital into the continuation of that intellectual property, and that's why you heard Ms. Watts discuss that we are in front of the patent court now and dealing with entirely new forms of intellectual property that are in the application stage, because we're trying to essentially revive what RxMM let fail and expire. The idea that we sold a product also is patently wrong. The Clarity is what was sold. Clarity owned intellectual property. The product had not been developed in any respect. And our understanding is that it still was not developed in any respect by the company. But regardless, those are all issues outside the pleadings. So the proper way to handle a promissory note case that is not in dispute, but where there is a disagreement over the amount owing, is to have a hearing. And if Ms. Watts is right that the value of this IP exceeds the $750,000 that Clarity and RxMM owe our client, then she will have the opportunity to prove that to you in a hearing over the value of the intellectual property. We're confident that you will learn, based upon the expiration of virtually all of this intellectual property, that it's relatively worthless, that the primary reason to have it is so that there were not competitive claims for the new forms of patents that our client is now actively working on for her efforts to finally develop this product. So the first point is that with respect to the pleadings, there is no dispute as to the validity of this note. There is no dispute that payments have not been made. Therefore, judgment should be entered on certainly Dr. Felton's claim, also Dr. Maida's claim, and you could have a hearing with respect to the appropriate amount of damages and any offset. The second point I want to make is to address head on this fiction about a cure period. I mean, the entire theory of RxMM's case is predicated on this idea that even though they unquestionably failed to make the payment that was due on October 31, that they actually had 30 more days to make that payment. And that's simply not true. I want to show you again, but I'm going to show you one additional document this time, because I think it's very important for you to understand what the cure period language says in the parties' respective agreements. And so if you look at what would be our Plaintiff's Exhibit 9, which I'm going to put up on the screen. Sorry, this is... Your Honor, this is the original promissory note that was signed by the parties in December of 2018. And this is the document that originally governed their relationship relating to the approximately $900,000 that was owing at that time. As you can see, default and event of default are defined in Section 5. So we go to Section 5, which is the section that Ms. Watts spent most of her time talking about. And her emphasis is on the breach language. Now, if you can see in the original note, a failure to pay under Section 5.1 is any maker fails to pay any amount when due. That's a monetary default. There is no 30-day default cure period. Now, under Section 5.3, is that on your screen, Your Honor?
Yes.
Okay. That addresses a failure to perform any covenant, obligation, condition, or agreement contained in this note, other than that specified in Section 5.1, and such failure continues for 30 days. So this is the language that RxMM relies upon for their claim to an additional 30-day grace period. But as you can see, the plain language of the original document that gave this 30-day cure period accepted Section 5.1. Section 5.1 being the failure to pay. So under the original promissory note, there could be no dispute that there is no 30-day cure period with respect to a monetary default. Now, the complication, which is pretty a word that I would say is generous, comes in when you look at the restated promissory note, which I will share on my screen, which is what we've called Exhibit 12. And this is, I've shown you this before. This is, once they defaulted under the first, they didn't even make the first payment. We dealt with them for months trying to get them to make another payment. And we signed this in September of 2019, along with the security agreement, along with the other forbearance agreement. And once again,
and this replaced the original note.
Yes, sir. This replaced the original
Anything
note.
dealing with default. And so
yes. And that's what I want to walk you through.
Yeah, go ahead.
So it has the same definition of default. This time, because additional section was added, default is the event specified in Section 6, right? And in the earlier version, it was Section 5. But we added a section to this amended agreement. So you go down to Section 6, and there you have the very same identical default provisions. Once again, 6.1, no 30-day cure period for a monetary default. Section 6.3 contains the identical language from the first agreement. The only difference is, as a result of a scrivener's error, we said other than that specified in Section 5.1, which, as you remember from the original agreement, was the non-monetary default section. Section 5.1 in this agreement is, the manner of payment, here. But obviously the parties, because they did not include any 30-day cure period in Section 6.1, and they incorporated the very same language into Section 6.3 to say that the 30-day cure period only applied to non-monetary defaults. It is obvious from these agreements that we didn't make the silly decision to agree to require that they make a payment on October 31, but then give them an additional 30 days if they didn't. That just isn't commercially reasonable, and it's obvious from looking at the context of these agreements that the plain language of these agreements did not provide such a period of cure. The other point that I would make, Ms. Watt said, well, but there are no other kinds of obligations under this agreement. Well, that's not true. If you look at the remainder of the agreement and the forbearance agreement, there were obligations under these agreements. I mean, one of those obligations has to do with the security agreements. And then if, more importantly, under the forbearance agreement, which I can show you, RxMM was obligated to provide routine disclosures of its financial condition. I'm sorry, I'm still scrolling, but I can show you the forbearance agreement if you'd like, but it's in front of you. Routine disclosures of its financial information, which it never did, and provide any financial information at our request, which it never did. And so the point that I'm trying to make is that as of November 1, 2019, Clarity and RxMM had not made the required payment. They were in default. And it is a major stretch for Ms. Watson for them to argue that they were not in default because of the 30-day cure period. Essentially, their entire theory relies upon taking advantage of a scrivener's error that, with context, makes obvious that there was no 30-day cure period. So on November 1, they were in default, and they knew that. And nobody made this argument that they weren't in default until we got before you, Your Honor. That's why they knew that they had the obligation to assign us the IP. Nobody said at that time, oh, I've got 30 more days. You know, yes, we were careful to give notices because we felt like we wanted to maximally comply, but the legal effect of their non-payment was clearly to put them in default. And I think all you have to do is look at the plain language of the documents that are before Your Honor and which are not contested in any way to make that determination. The third point that I want to make, Your Honor, is simply just to remind you of the merger clause and the assignment agreement. You know, everything that you heard from Ms. Watts about the negotiations and what was said and what was done, and he said this and she said this, and we were relying upon that, all with respect to negotiations over a merger that I'm happy to discuss, which which is irrelevant though to present purposes, is all irrelevant as a matter of law under the merger clause. What is the purpose of a merger clause if you are going to permit, and not you, sir, I didn't mean to suggest Your Honor, but if the courts are going to permit parties to just imagine a world in which there are other terms to the assignment, even though the parties agreed that there were none. So all of those claims fall as a result of what is a clear and enforceable merger agreement. And the only answer that Ms. Watts has for that is that, well, you know, after we got sued, after we brought counterclaims, and approximately 5.5 months after this assignment was made, we demanded rescission because we regretted having made the assignment. And that too, as a matter of law, is not a sufficient amount of time in which to demand rescission because the law requires it to be timely. You have to take immediate action once you're aware of all of the facts that give rise to the rescission. Well, as the very documents that Ms. Watts put before you showed, that within a week and a half of these discussions, we made clear that absent a lot more from RxMM to address what we considered to be very concerning information that we learned about the nature of this merger and about the other fraud allegations that have been brought in federal court against RxMM and others, which we learned in the week that we were negotiating these things, we were not going to negotiate. So they had notice from November 11th of 2019 of all of the facts relating to that we were not going to just blindly enter into a license agreement with them. And yet they waited until well after the filing of this lawsuit to ban rescission. That alone is reason to reject the rescission claim. The final point that I would make is that even Ms. Watts's own affidavit sworn testimony gives you more on the point of delay. So if I could share briefly with you the what we've marked as Exhibit 45. I mean, this is Ms. Watts's affidavit, and she's discussing some of the negotiations that we have had. And in paragraph 3 of that affidavit, she says that during a phone conversation in January or February, we told her that we were shopping this intellectual property. And of course, the motion for preliminary injunction that has been filed in this case wasn't filed until September. So, none of the actions in this case have been taken in a timely manner or in a manner that were designed to actually protect the interests that RxMM is here before you today to suggest they're protecting. Instead, they have been actions that have been reactive to our effort to enforce what is a undisputed, unequivocal, straightforward promise to pay. Now, I'm tempted, Your Honor, to go into the facts as to why our client decided, after learning more new information and also receiving financial information from RxMM, which was not updated past 2018, that she could not in good conscience
You're going to resist
license.
that temptation.
But I am going to resist it because I only think that
Because
becomes
we're dealing with
relevant.
pleadings, right?
That's right. It only becomes relevant with respect to the preliminary injunction motion. I have more to say with respect to that motion, but what I would suggest is that, you know, we conclude argument on the motion for judgment on the pleadings, and then we can talk about those issues if you think it's necessary. Thank you for the opportunity to rebut. I hope I didn't overplay my hand with telling you it would be brief.
Ms. Watts?
Your Honor, I just wanted to briefly address this point about the notice of default, since there's several new arguments that Mr. Kaplan's now put forward on this. I don't, this whole contention that there's a scrivener's error and we're looking at the prior agreement, the agreement that governs the 30-day cure period is the amended and restated note. And while it does say that a failure to pay is an event of default, that interpretation that there's no 30-day cure period ignores the additional language that says that if you fail to observe or perform any covenant, obligation, condition, or agreement contained in this note, and then it lists the forbearance agreement, the security agreement, other than specified in 5.1, and such failure continues for 30 days. There's no way to read this without, there's no other obligations under the note. He tries to point to obligations in these other agreements, but that makes that phrase, obligation contained in this note, then that makes that absolutely superfluous. That language clearly shows that there is a 30-day cure period. And again, if we look at the notice of default, that would govern this beyond this language of this agreement. The notice of default says it is a 30-day cure period until it becomes a capital N, or sorry, a capital E, capital D event of default under the agreements. They concede that. And then the email that I showed you on November the 27th, and I can put that back.
I know you don't have to do that.
Okay. Well, my point is that those emails further confirm their understanding that there was no right to sue my clients as of November 1st. There was a 30-day cure period, and our clients were acting within that. And the other point I will make, they're talking about patents expiring. The original patent was a 20-year patent that expired on its own. My clients then developed the Gen 2. Sorry, I don't know what just happened there. My clients then developed a Generation 2 patent that they paid money for. They hired an attorney to draft. And that's what's been in the patent office. It's not that my client slept on their obligations or their rights. They continued to develop this intellectual property. I will finally say that I would reject Mr. Kaplan's assertion that you should enter judgment on the underlying breach here. Our affirmative defenses are not just about the amount that's owed. Our affirmative defenses are about whether my clients had any further obligation to make payments under these agreements after the conduct that occurred, after the fraudulent conduct that occurred, inducing my clients to assign away a right that they had no obligation to do so. The merger clause is accepted by the rescission claim. That's the whole point of bringing a rescission claim, is to say that yes, under a breach claim, maybe we're governed by that. But the merger clause also wouldn't extend to the license. It wouldn't govern that obligation. And finally, I will repeat the argument that the rescission claim is not, we didn't delay in any of this. There were negotiations ongoing from November all the way through February of this year about trying to get them to make good on this promise of a license. And it wasn't until the lawsuit was filed that we fully comprehended that that wasn't going to happen. And so that's when we rescinded the agreement. And the other purpose of rescission being timely, the whole point of that is so there's no prejudice to the other party. the plaintiffs have suffered no prejudice that the rescission wasn't done in November versus April. They didn't ink their agreement to license the IP, which they claim has no value, yet they're entering into licensing agreements for it somehow. That wasn't done until October of this year. So there is no prejudice in any delay that might have occurred. And the delay that did occur was because we were trying in good faith to get the deal done and to have them live up to the license that they promised.
All right, let's adjourn until 1 o'clock, and we'll take up the motion, the only motion that's left to discuss, correct, for injunctive relief?
Yes.
Yes?
Yes, Your Honor.
All right. Be back at 1.
Thank you, Your Honor.
All right.
Hey, Ms. Watts.
Hey, I saw your email. I will,
Okay, yeah.
yeah, we're gonna split the cost with the plaintiff's counsel.
Okay.
Agreed to
Just
the
checking.
to split the takedown, but yes, well, I don't know whether, I'll get back to you. I'll respond to the email.
Yeah, no problem. Thank you, ma'am.
Council, this is Susan Shaver. Getting ready to restart the hearing. Do we have everybody here? Have I let everybody in that needs to be in? Mr. Kaplan, Ms. Watts, Ms. Stone. Let me see.
Yes, everyone from the plaintiff side is here.
Okay, and everyone from the defense side appears as present. All right, I am going to, Judge Coker is going to start, and we're going to move on with our injunction motion.
I don't see Annie on. Let me make sure she's,
Okay. Hang on, I see her in the waiting room.
okay.
All right. All right, Judge Coker, I think we're ready to proceed.
Okay, we're all back? Yes? Everybody's on mute.
Yes, for the plaintiff, Your Honor, we are all here.
We're hearing
Thank
this.
you.
Hey, Michael, you just went back to mute.
I'm sorry, Your Honor. I said for the plaintiffs, we are all here. Thank you.
So,
Yes, and for the defendant, we are all here.
all right, great. All right, so Ms. Watts, this would be your motion, correct?
Yes, Your Honor.
You ready?
Yes. I don't know. My phone keeps somehow ringing on my computer and I thought I shut that off, but I apologize if that happens. I'm not sure what technology fix that needs, but I think I'm going to shut down my phone and see if that helps. Okay. All right. So we're here now to discuss Clarice's motion for injunctive relief, and the elements of that, we're going to discuss the irreparable harm in absence of the injunction, the substantial likelihood of success on the merits of the claims, that the threat and injury to our client would outweigh any damage to the plaintiffs, and the public interest. Now, we've spent about 2 hours talking about merits of the claims, and interestingly, on a motion for judgment on the pleadings, we really didn't discuss the pleadings very much. We discussed a lot of factual issues and questions. So I feel like we've covered the likelihood of success on the merits. Although if there's anything in particular on those claims, Your Honor, that you would like to hear about, I'm happy to address that. Otherwise, I'll start with the irreparable harm, which is one of the primary elements of obtaining an injunction. And the cases that we cite in our brief, I think, speak for themselves, that courts have held that a loss of an ability to operate a business and a loss of a business opportunity constitutes irreparable harm as a matter of law. We cite the Celis In Vitro Inc. versus Cells Direct case. It's 664 F3D 922, the Federal Circuit 2013. that a loss of business opportunity is a valid ground for finding irreparable harm because it renders a final judgment ineffective. That's also from the Harmony International Spice Inc. versus United States case, 211 Federal Sup 3D 1298. That's the U.S. Court of International Trade in 2017. Another case we cite, the Tom Doherty Associates case, 869 F Sup 1130, Southern District of New York, 1994. Loss of the opportunity to distribute and market a commodity constitutes irreparable harm where the product is unique. These are all cases recognizing that Clearacy's lack of an ability to operate its business, which is unquestionably revolves around the nasal strip, and the loss of business opportunity that it is suffering from every day, constitutes an irreparable harm and warrants the award of injunctive relief. The plaintiffs didn't respond to any of these cases in their briefing. They focused instead on the cases that we cited under Georgia law, talking about unique realty. Those cases are instructive. Even though we're not talking about realty here, we are talking about unique property. And the parallel we drew to these cases was that those cases stand for the proposition that real property, is sufficiently unique that equity will enforce a contract for its sale and an injunction to maintain the status quo. In these cases, that's the Air versus Norfolk Timber Investments case, 291 Georgia App 409. And these cases recognize that money is not an adequate compensation to protect an interest in unique realty. Here we have unique intellectual property. There's no way for our clients to get the same intellectual property a different way. There is only one nasal strip here that they have an interest in. And other courts and other districts have also recognized the irreparable harm that a party will suffer if intellectual property that is at issue in the lawsuit is sold or transferred during the pendency of the suit. That's the Roder versus Trister case we cite. It's out of a district court in Oregon, 2 F Sup 3D 1153. And I think when you look at the irreparable harm here, the fact that the plaintiffs have taken action, as they've shown in their response, they have taken action to encumber this intellectual property and have actively pursued that even after we filed this motion for injunctive relief, despite being on notice since April that our clients dispute the plaintiff's entitlement to ownership of this intellectual property. At the end of the lawsuit, certainly my clients have a claim for monetary damages and they will proceed with that claim, but money is not going to make them whole when we have a loss of an ability to operate a business. Clearacy is nothing really without this intellectual property. So I think the irreparable harm element as outlined by these cases is pretty apparent. Now, when we look at the injury to our client versus the injury to the plaintiff, any injury here to the plaintiff is self-imposed. We cite the Sea Island Bank versus First Bullock Bank and Trust case. That's 245 Georgia 715, 1980. In that case, the appellate court affirmed an injunction where the plaintiff put the defendant on notice of an objection to construction of a bank more than 2 months prior to the commencement, and the bank went forward with the construction anyways. Here, we had clear notice of claims of rescission of this agreement as early as April 8th, I believe, of 2020 this year, that we sent the notice of rescission. The plaintiffs have been on clear notice that our clients contend that they have an ownership right in this intellectual property. We also cite several cases from other districts, one of which the Maids International versus Maids on Call. That's 2017 Westlaw 422-77146. That's out of a district court in Nebraska in 2017. And that court held that where a party brings harm upon itself by its own recalcitrant behavior, the party opposing the injunction can hardly claim to be harmed since it brought the harm on itself. Here, there is a great threat to our client of not having a business at the end of the day. If the intellectual property is encumbered, if this exclusive license deal goes forward after this, the third party, we don't have a lot of information about what this deal looks like. We asked for a copy of this proposed licensing agreement, and we weren't, they would not provide us with that, and haven't provided it to the court. The court, I don't think, really even knows what this licensing agreement provides for, but we do know that it's an attempt to exclusively license the intellectual property, at which point, at the end of this lawsuit, the court, if it finds in my client's favor, would be unable to award the intellectual property back. If we pursue our rescission claim, which we have asserted and think was asserted timely, then that relief would be to put the parties back in the position they were in before the assignment was signed, which means my clients would be the rightful owner of the intellectual property. But if it is licensed or sold or otherwise encumbered in the meantime, my clients aren't going to be able to have that opportunity. And also in the meantime, they are losing their business opportunity. And on the other side, again, while they claim that that this motion wasn't brought until September, we were in the middle of a pandemic, courts were closed, filing deadlines were stayed. I believe that the plaintiffs took advantage of that, and we asserted this claim in April, along with our rescission notice. It was no surprise that we were going to pursue this motion. And indeed, it appears from what limited information we have about this license agreement that it didn't come into an actual formal agreement until after we filed this motion. Finally, with regard to the public interest, we have cited cases in our brief that show that it is in the public interest to keep someone who may not be the ultimate owner of intellectual property from being able to license it or sell it when at the end of the day, they might be found not to be the rightful owner of the intellectual property. Finally, I'm going to address two of the arguments that the plaintiffs put forth in their response brief. They argue that the motion is moot because of the actions that the plaintiffs have taken. Basically, this is an interesting argument to say that the plaintiffs should be allowed to come in and effectively decide the issue that we have put before the court of who is the proper owner of this intellectual property by taking actions on their own and now saying, well, it's too late. We made an agreement after you filed this motion and you can't have this relief anymore. In fact, the limited information we have about this license through the affidavit submitted, which again, we've referenced in our response brief, that it is not under the best evidence rule. The court would not be able to rely on these statements in making a determination about the licensing agreement, but it's a conditional licensing agreement that they have admitted that the other party has to raise a certain amount of capital before they are entitled to the license. And my reading of that agreement, I think it's at a 4-month period, which I don't think has run. Again, I'm not sure because I don't have the agreement, but if it was signed in October, I would think that period has not run yet. So this conditional license they've entered into can be undone. And even if it can't, that burden should not be factored into this. If an agreement has been entered into and the plaintiffs are ultimately forced to breach that agreement because of actions they took, knowing full well that this motion was pending before the court, that is their own behavior. But it does not make this motion moot in any way. In fact, it provides, I think, a very good reason why the court needs to rule quickly on this motion. As far as the delay, we have discussed this in our argument on the motion for judgment on the pleadings. There has not been delay. My clients attempted in November and December to fulfill requests from plaintiffs' counsel to pay more money, make the payment, and we'll talk about the license. And then it was, here's a list of 3 pages of documents that 3 different bulleted page or different types of documents on 3 pages of a letter of documents that they wanted in order to keep discussing the license. And so my clients attempted to, they made the next payment in an attempt to continue the discussion about the license. They retained this firm in January. We had discussions with the plaintiff's counsel and we were attempting to get them to live up to the license. And yes, in my affidavit, I do say that they told us they were shopping the IP around, but that still doesn't mean they couldn't grant us the non-exclusive license that they promised. It wasn't until March when this lawsuit was filed that we realized that there was no intent to make good on the promise. And that's when we acted quickly to rescind the agreement and assert these claims. So there isn't a delay here. My clients have acted in good faith in an attempt to resolve this issue without having to resort to filing the counterclaims. But, once the lawsuit was filed, it was apparent that that's what they were going to have to do. Other than that, Your Honor, like I said, I think I've fully addressed the merits of the claims during the argument of the motion for judgment on the pleadings. But if there's anything in particular you would like to hear, I'm happy to address that.
Yes, I have one question. As part of the relief that you're requesting, is your client willing to post a bond in an amount equal to the balances of fees and interest and all that sort of thing that the plaintiff is claiming in this case?
I do not know
Pending the resolution of the issues, in order to get an injunction you want to restrict them from doing things with the property that they claim is theirs. Are you willing, while that issue is being resolved, to put up as a bond the amount in controversy?
I don't know the answer to that, Your Honor. I would have to ask my client.
Well, that would be something I would have to consider.
Your Honor, this is Mike. I would point out that the CEO of the company is.
Oh. It's Ms. Watts' turn.
Yes, sir.
Okay. Yes, ma'am. You were saying, I'm sorry.
No, I would need to speak to my client about that, and I would ask that it would not be in a Zoom hearing format. That I would have a
No. I'm not asking you to do it on a Zoom hearing.
Thank you.
I was just wondering if your client had considered that.
I don't know. I don't think we've considered. I don't think that's been advanced by the plaintiffs as something that they would.
Well, it's something that I have to consider, because when, if when you restrict somebody from using their property in the context of an injunction, and that's a hotly contested issue as to who owns what, if you lose that issue, and it takes us a couple years to figure out who wins this contest, they've been deprived of the use of their property during that time. And if your client doesn't have any money to compensate them, and of course, one of your theories is that they're not due any compensation. I understand that, but they wouldn't have anything to replace the value that they lost. Just think about that.
Yes, and I would also just add, Your Honor, that we're not asking that she not be able to do, or that the plaintiffs not be able to do anything with the intellectual property. We're just asking that they aren't able to sell it or license it or encumber it. They may certainly use it to profit from. They may, that's not what we're seeking to restrain here. We're seeking to prevent a situation where the intellectual property is sold or transferred, and at the end of the day, my clients are deprived from the relief that they're seeking of rescission or specific performance. That's really what we're focused on, but I'm certainly happy to discuss that with my client.
Well, but again, and talk to your client about what you just said, because if in fact they are deemed to be that whatever occurred here, the actions of the plaintiff were not warranted and wrong, you'd get the IP back, but then you'd have to pay for it. See, I mean, that's the theory of part of the theory of your case, that we shouldn't have to pay because we don't have the thing that we paid for. In this case, I mean, that's one of your defenses here. Well, if you get it back, then you have to pay for it. See? So in any event. All right, Mr. Kaplan.
Thank you, Your Honor, and I apologize for interrupting earlier. I want to start with your question. The status quo currently is that Clarity and RxMM owe Mrs. Maida Dr. Maida and Dr. Felton $750,000. If you are to restore the status quo to where the parties' rights have not been negatively impacted, then what that would require is the posting of $750,000, and not just the posting of it, but the payment of that amount to Dr. Maida. And I'm quite confident that if RxMM were to satisfy its obligation under the notes, which it promised to do beginning in 2016, that we would grant the non-exclusive license. So what they want is to have their cake and eat it too. What this reminds me of is I started clerking for Judge Richard Story in 2006, and I clerked for him through the economic crisis in 2008. And if you recall then, there were a lot of home foreclosures, and a lot of debtors came into the federal court and asked to enjoin foreclosure proceedings after they had failed to make mortgage payments for many months. In this case, it's been more than that. And you know, federal judges were tasked with dealing with the question of, well, how can I prevent someone from taking action on the rights that they have, the security interests they have, when you are not willing to make the payments? I don't understand. And ultimately, the federal court had to adopt sanctions rules to prevent these kinds of tactics from being brought. That is what we have here. We have a company who is not offering to pay anything, who has defaulted now on 4 payments at least, and yet wants to encumber the very security that it pledged in support of those payment obligations. That alone is reason to deny the injunction. The other point that I would make, sir, is that the promise that RxMM seeks to enforce, supposedly, the supposed promise, is one for a non-exclusive license. That is the language of the email that they have relied upon throughout this hearing. What they're asking for in this injunction is for you to limit Dr. Maida from doing anything with the intellectual property. The very best case that they could ever win, if they were to win their claim, is the idea that they would have a non-exclusive license, which does not restrict Dr. Maida in any way from licensing the IP to others. So the nature of the relief that they have requested is also completely disproportionate and contrary to the very obligation that they purport to be enforcing. So I just want to make those points at the outset. I think if you were to even entertain this, you would have to require them to satisfy their obligations to Dr. Maida and Dr. Felton, as well as only have a limitation that protects against the non-exclusive license. But again, we don't think you should even get there for the reasons that I will now talk about. So, Your Honor, I have just a brief presentation set for this because I think there are other legal barriers to this motion that we've spent a little bit of time briefing. I'm going to share my screen just to show you a couple of those points. So first, Your Honor, I'm going to talk about the 3 primary arguments that we've made in response to this motion. The first is the laches doctrine, the delay that RxMM showed before filing this motion itself requires its denial. Also, the motion is moot because Dr. Maida has already entered into an agreement that encumbers this intellectual property. And finally, RxMM fails to meet any of the 4 very high hurdles that are required for the extraordinary relief of a preliminary injunction. So the first issue, Your Honor, is laches. And we've cited a Georgia Supreme Court case, which is, of course, the seminal case. There are many that follow, where judges have not even reached the merits of preliminary injunction motions because parties have delayed in asserting those rights. And the reason that delay is important is because delay reflects the lack of irreparable harm. If somebody really believed, if RxMM really believed that it was going to suffer irreparable harm from Dr. Maida taking some kind of action to license this intellectual property, then one would think that they would have taken action beginning in December of 2019 when they made a payment and made this argument that they should get the intellectual property back. But instead, they did nothing. They waited that 10 months. They then, had continuing discussions with us. We made it clear that we were not going to, after they refused to provide certain information, which I'll talk about in a minute, we made clear that we would not license the property because we were concerned with participating in a criminal fraud against prospective investors, and yet they still did nothing. I think the most significant evidence of their delay and their latches is from Mrs. Watts herself. In her own affidavit, she indicated that, and she acknowledged that we were very transparent with her and her client about the fact that Dr. Maida was taking action in February and late January of this year to encumber, sell, transfer, license this intellectual property. This was pre-pandemic. This was, now 7 months ago. There was nothing preventing RxMM from coming into court and stopping us from doing the negotiating that we told them that we were doing at the very beginning of this year. So these excuses about, oh, well, it's the pandemic. I mean, the courts did not shut down ever. They just extended deadlines. But, we told them about this well before the pandemic. I mean, this was January and February of this year. And then, since then, RxMM has filed numerous motions. I mean, they had time to file a motion to dismiss on the basis that, we had to go through 4 months of international Hague service in order to try to avoid the accountability of this court. But they didn't file a motion for preliminary injunction. Instead, they sought to avoid jurisdiction of this court by forcing us to go through Hague Convention International Service to enforce a note in which they consented to the jurisdiction of this court. So, I mean, the idea that they couldn't do it is patently absurd. They chose instead a different strategy when that didn't work because we went through the expense of serving RxMM in Australia. And only then did they decide to file this injunction when they knew we were on the verge of filing our motion for judgment on the pleadings. So just by virtue of their delay in this case, this motion should be denied. Now, secondly, because of their delay, Dr. Maida was ultimately successful in entering an agreement with a third party relating to this very intellectual property. And we've put in evidence of that agreement. There's no dispute as to that agreement. And that alone renders this motion moot. And it's not us. I mean, we shouldn't be to blame for seeking to obtain some value from the intellectual property that we ultimately were unsuccessful at obtaining value from Clarity. I mean, what are we supposed to do? Just sit on our hands and imagine a world in which an injunction existed because they hadn't filed one? No, they delayed. And so Dr. Maida properly did what any person would do who owns intellectual property and sought to take advantage of that. She has successfully done so, and that renders this injunction a moot question. And that's not our fault. That is the fault of RxMM for delaying 10 months from bringing this motion. The case law is clear on this issue. Once the thing sought to be enjoined takes place, the grant or denial of the injunction becomes moot. That's the Jackson case in the Georgia Supreme Court. Again, if the thing sought to be enjoined in fact takes place, the grant or denial of the injunction becomes moot. Clark versus Deal, 2016. So they have sought this broad injunction which seeks to prevent us from doing anything with the license. Of course, like I said, far in excess of even the promise that they purportedly seek to enforce. And that has happened. And even though the intellectual property hasn't been fully sold, that the case law doesn't require a sale. It requires that you take some action that is the subject of the request for injunction. Well, they have requested that you stop us from, licensing or encumbering the intellectual property. We have already done that. So, I mean, there's just no factual dispute that the request for an injunction is now moot. Now, the third point here, Your Honor, is the merits. I mean, if you choose to reach the merits, which I don't think you need to do, of course, the first thing that you look at is whether Clerisy and RxMM is substantially likely to succeed on its claims. And for the reasons that we argued earlier, we don't think that even legally there is a viability to RxMM's theories of fraud. As we've already argued, the false statements on which they premise their claims of fraud are non-actionable in and of themselves. And secondly, there's no duty, and the claim for rescission was untimely. There are no circumstances warranting equitable or declaratory relief. The other point that I would make is that, I mean, even today, because of the failure by RxMM to make the required payments under the note, the status quo is that we can foreclose on the IP. So how are they substantially likely to prevail under circumstances in which there is no dispute that they have failed to meet their obligations under the note agreement? I just don't even understand how one would make that argument. And the plain language of the IP security agreement provides that we are allowed to take possession of, hold, collect, sell, lease, deliver, grant options to purchase, otherwise retain, liquidate, or dispose of all or any portion of the collateral if they were to breach the note. And there's no dispute that they've breached the note. So not only is there no substantial likelihood of success on their claims, there is zero likelihood of success on their claims, because if we were to assign them back the collateral today, because they are in default of the note, we could take it right back. So as you said at first, Your Honor, I mean, the only possible way they could ever begin to win an injunction in this case is if they were able to satisfy their obligations under the note so that we didn't have the present and immediate right to seize the IP back from them under the security agreement. I also want to just take a step here and talk about the facts, because my prediction is that you're not ultimately going to hear witness testimony, but I want to make a very brief presentation to you about why, if you heard the testimony of Dr. Maida, why we began by discussing the possibility of licensing Clerisy, a non-exclusive interest in the IP. And then after going through some weeks of investigation, we ultimately decided not to. And I only need to give you a few facts and show you a few documents on this, right, I think, for you to get the point.
Your Honor, I'm sorry, I would object to this. And the reason I'm interrupting is because, as we said at the beginning of this, I was planning on questioning some of the witnesses here. What Mr. Kaplan has just said is that in lieu of calling his client to testify, he'd like to just share some facts on his own as he understands them to be. I don't believe that's proper on a motion for preliminary injunction. He's got a witness here. He can call her if he believes that there are facts appropriate to be shared, but I don't think we need to take Mr. Kaplan's word for what the facts are. We should hear those from the witnesses.
Well, I'm going to allow both sides to proffer their version of what they think the evidence would show. And if I feel like I need to actually hear the evidence, then I'll listen to the witnesses. But I would encourage each side to, follow that direction. And of course, after you listen to whatever facts Mr. Kaplan wants to proffer, the fact that he proffers them, I know, does not suggest that you agree that's the state of things. And you're more than capable of, proffering whatever the evidence is contradicts that or is different than that. Let's see if we could do this without having to call witnesses. Go ahead.
Thank you, Your Honor. That's exactly what I'm trying to do here. So as Your Honor knows, we belabored the point, October 31, 2019 was the day that RxMM owed us the second payment under the amended forbearance agreement of $225,000. And that day came and went and the money was not paid. And so on November 1, we sent our demand letter and we said, we're going to sue you and we're going to do so immediately unless you assign the intellectual property. And discussions ensued among the parties about whether Clarity and RxMM would be able to make that $225,000 payment. And so what I want to show you now is one of the emails that concerned that issue of Clarity's statements to us about the source of those funds. So as Your Honor can see, this is up on your screen, I hope.
Yeah.
Okay, so this is a November 2nd email from Giza Molnar, who is the Chief Financial Officer of Clarity. And this is the same email that we showed you earlier in which Clarity accepted our demand that the intellectual property be assigned. And so if you look at the last sentence of this email, Mr. Molnar indicates, quote, "Please be aware that upon execution of a definitive merger agreement, Clarity will receive funds to meet its November 30, 2019 financial obligation of $225,000. So what Mr. Molnar is telling us is that as long as you license us the intellectual property and you allow us to close this deal, we are going to get $225,000 and then we are going to pay it to you. That's what they said to us. And, you know, we listened to that and we said, okay, I think I understand that. You're going to raise capital, and as a part of that capital, you are going to pay us our note obligation. And so that didn't immediately strike us as problematic. Well, after these communications, we did a little bit more research. And this is the first document that we found. This is what would be Exhibit 38 if we were to introduce any evidence. And this is the LOI that I believe Ms. Watts referred to earlier that gives the terms of this very odd reverse merger with a penny stock company on the Pink Exchange. And you can see that it's a complicated reverse merger involving mixing shares of companies. But the key clause, which relates to the cash, is under paragraph 4 in transaction. And where I have included this arrow, it says that Global shall promptly pay a non-refundable deposit of $25,000 and then shall enter into with or fund to the order of Clarity a loan in the amount of $225,000. So the transaction that is being contemplated here is this strange equity to equity reverse merger with a penny stock that also involves a loan of the very same amount that is owed to Dr. Maida and Dr. Felton. And so we realized, okay, now we're not talking about a capital raise of equity, we're talking about a loan. So then we looked at the press release that Ms. Watts referred to earlier. And I'm gonna share that with you, which is Exhibit 43, if we were to introduce this evidence. And I'm sorry. And so this is
sorry, I object to this. This is hearsay, and Mr. Kaplan's trying to get it in on his own. His witness couldn't even get in this exhibit. This is unauthenticated, inadmissible hearsay that has not even been shared with the other side until minutes before this hearing started. This is not part of the pleadings or the record or anything that has been submitted before. And I would ask that Mr. Kaplan not present unauthenticated and admissible hearsay as a part of his proffer of testimony.
Okay, I agree. I don't think you need to go into that for purposes of this hearing, and certainly.
Your Honor, may I just briefly respond?
Oh, please don't respond to that. Just move on.
Okay.
Thank you.
Well, so I won't show the document, but the conclusion point here, Your Honor, is simply that if you were to evaluate the facts for purposes of making a determination about substantial likelihood of success on this alleged fraud claim, what you will learn is that upon this investigation, which we're not offering any of this for the truth, that was a publicly available document. What we're offering it for is to show what the mindset of Dr. Maida was in these negotiations. And you will see that we learned that on the one hand, Clarity was indicating that they were raising capital that was to be used for working capital to develop products. And on the other hand, the same $225,000 was being promised to Dr. Maida for payment of the note. And what happened was we became concerned that we were going to be involving ourselves in a criminal fraud to either enter into this merger transaction or raise capital from investors who were being told that $225,000 was being used for working capital, when in fact, at the same time, it was being promised to Dr. Maida. And so the idea that we committed fraud by entertaining licensing negotiations, but then doing independent investigation and determining that it was not in Dr. Maida's legal interest is absurd, and they are not likely to succeed on that claim. In addition, Your Honor, I would simply point out that I sent a letter to Clarity, which was represented by Ms. Watts at the time, and demanded basic financial information that any company involved in a merger would have: a balance sheet, a income statement. And the response that I received was that Clarity has not maintained financial information since 2018, and that it has not filed tax returns. And so once we learned that information, I advised my client, or I won't say that, but my client came to the conclusion that it was probably not a wise decision to license this technology. And so again, the first element of a motion for preliminary injunction is substantial likelihood of success on the merits. I believe I've shown you that they cannot succeed on the merits legally because their counterclaims fail as a matter of law. Factually, if we have to go into it today, we will be prepared to both cross-examine the Clarity CEO on these matters, as well as to offer Dr. Maida's testimony to this effect. Your Honor, rather than share my PowerPoint presentation, I'm just going to briefly go through the remaining factors of a preliminary injunction.
All right.
In terms of irreparable harm, I've already made the point that irreparable harm is undermined by Clarity and RxMM's own 10-month delay in bringing this motion. There is no irreparable harm that they would suffer, especially from the relief that they have requested from you, which is simply encumbering this asset. They're not asking you to transfer the IP to them. They're not going to be able to use the IP during this litigation. So Ms. Watts' entire argument was predicated on the fiction that they would be able to use the IP during the litigation, which they would not. And like I said, at best, they would only ever get a non-exclusive license. So we don't believe they've shown irreparable harm. They've also made clear that they're seeking monetary damages in this case, which would be adequate to address any of the concerns that they've raised. The damage to Dr. Maida would vastly outweigh any harm to Clarity from the grant of this injunction. As I said, it's far broader than what Clarity would ever be entitled to. And it would completely override the rights that she has under the security agreement and her ability in a very competitive environment to move forward with licensing this IP to a partner that is capitalized and able to pay her for its value. And so if you were to grant this injunction and prevent her from doing that, essentially she would not only have lost the 4 years that she has already because of Clarity's failure to pay her for the IP, but the IP will continue to lose value, or no one would have sufficient incentive to fully maximize it in a competitive environment where many others are trying to pursue the same kind of opportunities. So if you balance the scale of harm, the harm would fall on Dr. Maida exponentially to Clarity and RxMM if you were to grant this injunction. Finally, the injunction is against the public interest because, again, the public interest is in enforcing contracts, enforcing promises. And here, there's no question that Clarity and RxMM have not paid for the value of this IP. And so it would go against the public interest to essentially forbid Dr. Maida from using IP that she rightfully owns, and while allowing Clarity and RxMM to encumber that without having met their unquestionable obligations to her. The final point, Your Honor, that I would make is simply that if you were to ever consider granting the injunction, we would certainly request that the defendants be required as a condition of entry of any injunction, the full balance that is owing to Dr. Maida and Dr. Felton, along with an additional bond in an amount that would properly compensate her if she loses other licensing agreements from other parties. And, should the court be open to testimony in that regard, we would be prepared to present it. But I actually don't think $750,000 would be enough. But I don't think they're prepared to pay it anyway. And certainly the CEO of the company is on the phone here today, and I surely could answer that question, since that could solve this issue fairly quickly.
Watts, you want a rebuttal?
Your Honor, I think I've already addressed your position on bond. I'm happy to speak with my client about that at the appropriate time. I want to address this conception that our best case and our best day is a non-exclusive license. That's not true. My clients have a claim for rescission, and rescission would mean that the intellectual property would go back in their possession. So it's not that, our best day would be getting a non-exclusive license here. The best day would be getting it back. And obviously they would owe money, but there are other claims here that would get factored into that. There are claims for damages from the loss of the merger. There are claims for punitive damages. And we believe that those claims will result in monetary compensation. And so any additional amount that may be owed under these notes, if the intellectual property, if the agreement is rescinded and put back in their hands, I think that's not an issue as far as I see it. For yes, there would be money owed, but my clients, I think, would certainly be able to pay that. In addressing the delay issue, again, the fact that Dr. Maida was trying to license the intellectual property in February and of this year doesn't show anything. At that point, we were trying to negotiate a license. How are we going to negotiate a license by filing a lawsuit and rescinding the assignment? We thought we were negotiating. We were in good faith, thinking we were going to get to a resolution of this license agreement. Surely by rescinding the agreement or filing a lawsuit, that would have put an end to these negotiations. That's not the path my clients chose to take. They chose to continue to try in good faith to get this deal to happen. So there isn't a delay here by my clients. At the point that they realized that wasn't going to happen, they rescinded the agreement. And again here, delay, you look at lack of prejudice. As of April, the plaintiffs are on full notice that my clients had a claim to this intellectual property, that they had rescinded the agreement, which they rejected. My client still had a notice of rescission out. And so the prejudice and the harm didn't come until after we filed this motion. She signed this deal after we filed our motion. And there's no recognition of that in the delay. There wasn't a delay in asserting the claims, and we brought the motion at the appropriate time. And to say that serving RxMM had anything to do with that's entirely speculation on Mr. Kaplan's part, and I will tell you had nothing to do with it. And I will also say that we didn't even know that they were going to file a motion for judgment on the pleadings at the time that we filed our motion for injunctive relief. We didn't know about that. So to try to tie those things together, that had nothing to do with it. The courts were closed. That had an effect on everything. And our client brought the claim in their counterclaim in April, put full notice of this claim at that time, and then brought the motion after the case had been transferred to the business court. And we felt like it was the appropriate time and that there was a court and a judge that was available to address the motion. And again, I would say that any action taken on this time, that Sea Island Bank case that I already cited to you, they hadn't filed a motion for injunctive relief at the time. All the party had done was let the bank know that they objected to the bank building the building, and the bank went ahead with building it, and the injunction came much later. So it wasn't a test of when were you on notice that there was a motion for injunctive relief pending. It's when did you know that the other party objected to your right to take the action? And that was clear on our part as of April 8th of this year. On the mootness issue, again, this is not a done deal. The intellectual property has not been licensed. We still don't have any explanation of why this agreement is not before the court. We don't have any explanation of what's going to happen and what the timetable is. But my reading of the agreement that wasn't corrected by Mr. Kaplan is that money is still being raised and the intellectual property has not, in fact, been licensed yet. And that deal can be undone. They entered into that agreement after we filed the motion for injunctive relief. How can they be rewarded by trying to take this issue out of the court's hands by entering into an agreement and then saying, well, it's moot, we're sorry, you can't have the requested relief? That behavior should not be rewarded. On the likelihood of success on the merits, again, the IP security agreement requires a capital E event of capital D default. And we have already, the documents, I'm not going to belabor this point again. You've done this for a long time. I trust you can read these documents. You can read their notice of default. You can read the emails that came later acknowledging that there was a 30-day cure period for this. And an event of default never occurred under the IP security agreement such that she could take back, that the plaintiffs could take back the intellectual property. We deny that we were ever in default after the payment was made on December the 2nd. There were no further payment obligations at that point. And as you pointed out, there's a questionable obligation to even make that payment at that point, that the agreement had been repudiated, that the obligation there was clear there was not going to be a license at that time without additional actions taken by my clients. And so, and I would also say that you did not, I don't believe I heard you to say that we needed to pay the plaintiffs money in order to get this injunction. I heard you say posting a bond. And I think that's different from making payments under an agreement that we dispute whether there are any payment obligations actually to be made. I think a bond is definitely clearly different than putting a check into the plaintiff's pocket. On the testimony, we do have Mr. Lyndon James here today, and he can explain the reverse merger deal better than I can. But if he were to testify, if you were to hear the testimony, he would explain to you that this was not some sham deal. This was a legitimate deal that Clarity was engaging in to attempt to make good on their promise to pay. There is no dispute that they had trouble making these payments, but they were attempting to capitalize the company properly and make payments. To the point about the 225 and the loan, in addition to entering into this agreement with the letter of intent, Clarity was also doing a friends and family capital raise. They had raised $400,000 And we're continuing to raise money through that. So they weren't intending to make a payment based on a loan. They were raising money through a friends and family raise. They were also, after the merger was completed, going to have a $4 million capital raise. And it's through these funds that they expected to pay for the outstanding obligations. The financial records that Mr. Kaplan referred to, he's talking about conversations that we had in January and February of 2020. These are irrelevant to the fraud claim of whether there was an intent to give a license. What they knew in February of 2020 has nothing to do with whether there was an intent back in November of 2019 to give the license. Whether they ultimately decided in February that there wasn't enough financial information to give the license, that's not what our claim is based on. The claim is based on November the 4th, when Dr. Maida's counsel said, if you execute this agreement, we will give you a license. The question is, on that day.
Wouldn't that have some bearing though on the question that we're considering now? Injunctive relief, the financial ability of your client as well as its new partner.
It's relevant to whether they can post the bond?
No. I mean, you're asking for the injunctive relief. You has something to do with the fact that you want to go into business and be able to use this with some new financing and that sort of thing. Yeah? No?
Well, eventually they would, yes. I mean, they got the intellectual property back, then they would be using it to make money.
All right. Go ahead.
Okay. On the irreparable harm issue, again, our best day is not just getting a license out of this. Our best day is to rescind the agreement and have the intellectual property put back in my client's possession. And the fact that we're seeking monetary relief in addition to this does not mean that there's no irreparable harm. The case law we've cited is unrefuted that a loss of business opportunity is in fact an irreparable harm. The damage to Dr. Maida, I hear all of the points, but what I'm brought back to is that she had a way to get the intellectual property back. There was an IP security agreement that had my clients defaulted, then the plaintiffs would have been able to take back the intellectual property, but it comes with provisions. It comes with being governed by the UCC. It comes with notice provisions. It comes with foreclosure sale provisions. And it comes with a requirement that the value of the collateral is determined and that if a surplus exists, that amount goes back to and is accounted for. And that's what they were able to skirt by instead convincing my clients to assign the intellectual property under extreme duress. So if there's any detriment here, it's not because my clients have put that situation. It's their own doing if they have any damage here. As far as the public interest goes, I think there's a public interest in dealing in good faith with parties that you contract with. And that was what was required here. That is not what happened. And to the last point of the additional compensation, I don't know that there's any legal authority for the court to require additional monetary compensation. I think that what the court was discussing of a bond, I think I've obviously seen that in injunction situations before, but I don't think there's any authority to require some payment to the plaintiffs of the amounts owed plus some additional amount to compensate some harm that is not before the court right now.
Okay. Anything else?
Well, and I will also add at the end, I mean, Mr. Lyndon James is here. We were prepared to give his testimony. I wasn't prepared to proffer his testimony because we thought he would testify, but he would testify. I believe what his testimony would be is that this is about these emails, that under the extreme duress of the situation, they agreed to something and they trusted the plaintiffs and their attorneys to make good on their promise to give this license. And when that didn't happen, this merger deal fell apart. And so did their ability to make payments, which, obviously our position is that also went out the window when the plaintiffs didn't make good on their promise, but they were intent to try to make these payments. It didn't work out the way they thought, but they were intent to make these payments. I think he would also testify about this merger deal and what was going on with it and his confidence that it was going to go forward and that it was going to enable them not just to pay back the plaintiffs, but to also develop this product and to have a marketable product for the company and to make money for the company.
Okay. Actually, I would like to hear from him on the limited topic of this merger thing and what the expectations were and why they were.
Okay. Thank you, Your Honor. Mr. Lyndon James, would you please take your microphone off of mute so I can ask you a few questions?
Yes.
There you go. Thank you.
And Your Honor, can we make sure to swear the witness, please?
I was just about to do that.
Oh, wonderful. Thank you.
Thank you.
Could you, excuse me if I may, just take a quick comfort break? I won't be a moment.
Go ahead.
Could you give me a moment? Thank you. Thank you.
That's fine.
Okay, I'm clear.
Very good.
Thank you. Mr. Lyndon James, will you please raise your right hand? Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Can you please introduce yourself to the court?
Yeah, I'm Ross Lyndon. Pardon me. I'm Ross Lyndon James. I'm the Chief Executive Officer of Clarity. I'm an Executive Director of RxMM. I'm one of the founders, a co-founder of RxMM, and I was the party involved in the negotiations to acquire Clarity with Dr. Maida.
What is the relationship between RxMM and Clarity?
RxMM formed Clarity, or actually, excuse me, acquired Clarity to produce a medical device for the delivery of medical marijuana. RxMM Health set itself up originally as a business to pursue opportunities in the medical marijuana space, and the relationship was that RxMM funded the acquisition of Clarity and provided it with operating capital.
And at some point after, I'm going to try to get quickly to the point here that Judge Goger wants to hear about, but is it true that at some point after acquiring Clarity, you discovered that the nasal strip did not work for the medical marijuana purpose? Is that right?
That's correct.
Okay, and so what did you do after that, after realizing that the purpose of the device did not work as hoped for in purchasing the company?
We realized that the only way we could profit or make a success of the business was to go through a general marketing program to put the product with nutraceutical medicines, if you like, into traditional retail operations and retail outlets. So we actually went back to the original plan that Dr. Maida had to publicize and promote and market the device. So it was a total pivot from what we originally intended to do, because we had a captive market in California with the licensed dispensary stores that would have marketed the product. So it was a major setback for us to revert to something that wasn't our business model and wasn't our business interest. Our primary.
You were reverting back to the model that Dr. Maida had used prior to purchasing the company. Was Dr. Maida successful with that business model of using the neuronasal strip for natural medicine?
At the time that we acquired the business, there was no evidence of any commercial success. There'd been some marketing attempts using different avenues, and there'd been an in-store product placement trial with a supermarket chain, but we had no evidence and nothing offered to us to show there'd been any commercial success at all. And in fact, at the time, the last production run for the product was some years before the acquisition. So the sample product that was available was several years, it had been several years idle.
And so tell me about Global and who Global was and what the plan was to do with Global when you still owned the intellectual property that is the subject of these proceedings.
Okay, well, it's important to recognize it's not just the intellectual property that was of value here. The fact that the technology was FDA approved and had at that time still had some patent coverage was the value. So you had a medical device that was FDA approved and still under patent coverage, although the patent life was running out. So I engaged, excuse me, pardon me. I engaged an investment banking firm, SC Capital, and one of its principals, Steve Fryer, who had experience in taking medical device and other medical-oriented products onto the Toronto Stock Exchange. I engaged him to see if we could do the same thing, and their model was Toronto Stock Exchange has a facility for shell companies or companies to be formed and funded with a limited amount of capital, but to achieve public listing status and sit there for 2 years while they sought a viable business to merge into them. And that facility and that operation still exists. So Mr. Fryer had experience in taking American companies up there to do exactly that, to merge into a listed entity that was seeking a business opportunity. And so we engaged him for several months prior to the trip, and the preparatory work was done. We were paying him, he was under a fee arrangement, and he was under a success fee arrangement to help us with the transaction. He identified Global Investments Capital as a viable listed entity to merge into, and approached them, and they responded positively. He engaged, or actually referred us to SEC legal counsel to handle the transaction, and he introduced us to an accounting firm that would conduct the audit, because both entities had to be audited in order for the transaction to be completed. So Global Investments, under the terms of that, under the terms of the Toronto Stock Exchange Ventures regulations, that company was able, it had some capital in it, limited capital. At the time, it had $440,000 in the bank account, and it was able to make, on the basis of an agreement being signed, it was able to advance a loan to the company. And the maximum amount of that loan was $225,000. So it happened to be a coincidence in terms of the amount, but we were keen to complete the merger, to be followed by a capital raising of $4 million once the merger, the reverse merger, had occurred. And pardon me, we had a friends and family offering underway at the time, so we had some capital coming in. So the combination of the two amounts, the availability of the loan out of the intended listed entity to merge into Global, and our own capability, we're able to service the payment. Claris Securities, I met with Claris Securities on that same trip to Toronto, and we reached agreement to engage them to raise $4 million in a placement, a secondary offering, post the merger. And so we therefore had ended up as a result, we would have Clerisy as a listed company on the Toronto Stock Exchange Ventures market with listed securities, and we had a broker ready to make a placement to their client base, their offering rather, to clients and others to raise the 4 million. So, the press release that was put out by Global regarding the signing of the letter of intent was also noticed to the Toronto Stock Exchange, and it was an official step forward. It was a practice that the Toronto Stock Exchange Ventures market supported and promoted heavily. It had been a successful way of small companies becoming listed and having their securities traded publicly so they could raise capital in the early stages of their development. And this to us was the ideal path to take a company that had no sales, had technology yet to be commercially proven, onto the market and access the capital markets as opposed to venture capital markets or private investors.
And Mr. Lynn, James, I want to just show the letter of intent briefly, if I may. Do you see this document dated October 2nd, 2019?
Yes.
Okay, and is this a copy of the letter of intent between Global on the one hand and Clerisy on the other hand? And I'm going to scroll down here for a second. Did you have counsel help you prepare this document?
Well, it was prepared by Global and was reviewed by our counsel.
Okay. Is that, whose signature is that underneath Clerisy Corporation?
It's the CEO of as far as I know, that's the CEO of Global.
Okay, and the signature under Clerisy Corporation, is that Geza Molnar?
Yeah, that's Clarisy's CFO.
Okay. And so this letter of intent was signed by both Global and Clerisy, is that right?
Correct.
Okay. And you were talking a moment ago about a trip that you were making up to Canada. Can you tell me when was that trip, or were there multiple trips?
Oh, there were two trips. The original trip was the first meeting with the individuals that were associated with the potential of merging, and to meet the legal firm that our consultant Steve Fryer had used in the past to make sure that we had the necessary services available to the idea of conducting a reverse takeover. So that was one trip. The second, which was a prospective trip, the second trip was to travel to complete the arrangements with Global Investments to initiate the actions to be taken for the merger, and to meet with Claris Securities for the subsequent offering to be undertaken, the raising of 4 million following the merger.
And was there a trip to Canada that was planned at the beginning of November 2019?
Yes, that's the trip I'm referring to.
Okay. And were you on your way to Canada for this trip when you received Ashley Brown's email on November 1st enclosing a notice of default?
Well, we had booked the trip to leave on the Monday, I think the 3rd, and we received the first letter on the Friday, the 1st. So we were midstream, arrangements in place, appointments made, meetings set up, and travel arrangements and air tickets and so on had all been put in place. So we were not yet in transit, but ready to leave when this unfortunate development occurred, leaving us in a very, very difficult situation. We couldn't go to Canada and continue with the reverse takeover transaction and negotiations unless we had a license. there was no point in going. There was nothing going to happen if we didn't have the rights that we had already told them we had, and they'd reviewed. So without getting a license or the undertaking at best to license the technology as a result of the actions taken by Dr. Maida's firm, a legal firm, we had nothing to sell, we had nothing. We were rendered useless. So it was critical to achieve an understanding, and we couldn't go and give undertakings or purport to have something if we didn't have it. And because we believed that the payment of the money would in fact allow us to negotiate a license, we carried on in good faith.
And so I'm showing you, if you'll look at the screen, a copy of the notice of default that was dated November 1st, 2019. Did you receive, I see your name is on this. Do you recall receiving?
You don't need to go into that. I just wanted to know really about the merger, you know, sort of how it came about, how it didn't work out. That's really all I wanted to know.
Okay.
These other documents speak for themselves, I guess. Anything else?
I would just ask that Mr. Lyndon James to describe for the court, when you receive these emails that we've all looked at multiple times, the ones that threatened immediate legal action and told you that you needed to assign the IP immediately to avoid a lawsuit. How did that make you feel, and what type of impact did that have on your upcoming trip?
Well, it was from my point of view, it was verging on disaster, because everything that we'd done to that point, we saw we could capitalize on through this method of emerging into a listed Canadian Toronto Stock Exchange company and raise the capital to make a success of the business. So it threatened not only our interests in achieving that and the work that had been done and the investment made to date, but the threats contained in the letter from Mr. Kaplan were far-reaching and devastating. And so I felt threatened to the point of being very, very concerned, because it really threatened to bring down a whole lot of shareholder interest. I mean, it was a potentially a lethal blow to us.
And was Clarity or RxMM represented by counsel in connection with these emails and letters you were receiving from Mr. Kaplan's law firm?
In the earlier days, we had counsel who had interacted on our behalf with Kaplan, the Kaplan firm. He subsequently left the company, and we, at the time that this happened, these events in late October, early November, we had no legal counsel. We were without counsel, and we didn't refer to counsel in responding to the demands.
And did you understand that these emails from Ashley Brown at the Kaplan Cobb firm, that they were communications on behalf of Mary Maida?
Ma'am, really, you don't need to go into that. I accept you made a proffer earlier about how these emails affected your client, and I understand that.
Okay.
Anything else?
No further questions.
Thank you. Ms. Kaplan, if you have some questions, keep it brief, please.
Hi, Judge Goger. This is Julia Stone. I'm going to ask a few questions.
Oh, sorry. Excuse me, ma'am.
No problem. And I will keep it very brief, just to the try to keep it just to the terms of what Mr. Lyndon James just testified about. And I want to start where you started, Mr. Lyndon James, about the purchase of Clarity by RxMM. And you said that, if I understood your testimony correctly, that there was no commercial success and no proof of commercial success of Clarity when RxMM purchased it. Is that correct?
Substantial was the word that I used. There was no substantial success. No, nothing evident to us at that stage there'd been any substantial commercialization.
So no substantial success, but RxMM still agreed to purchase the company.
Yes. Well, originally we didn't set out to purchase the company. We set out to license the technology to apply to medical marijuana delivery.
But the agreement was ultimately reached.
Yes, but I think the point here is that we never wanted to be in the same business that Dr. Maida's business was at that time. We wanted to use the technology as a FDA-approved medical delivery device for delivering medical cannabis, and that was our business. At the time of the offer, Dr. Maida suggested that if we're going to pay that much for a license, why not buy the whole company? And that's what led to the purchase of it.
So you ultimately agreed, my question, you ultimately agreed to purchase Clarity.
Yes.
And you don't dispute that RxMM and the Clarity that RxMM purchased didn't ultimately pay all of the amounts back to
I don't dispute that at all.
And I want to talk just about the global merger quickly. If I understood your testimony correctly, you said that the terms of the merger were going to be a stock transaction plus this $225,000 loan, correct?
Yeah, that was incidental to the merger. The merger was a stock transaction, and the fact that we ended up in an agreement to reverse merge into there under the terms of the TSXV, Global could make a loan, which obviously became subsumed through the merger. So it was an ideal access to working capital.
And the capital raise that you talked about, if I understood you to your testimony, was the capital raise was going to come after the merger, the definitive merger agreement had been signed, correct?
Correct. It was, yes. And we were putting the capital raise agreement in place on that trip in early November.
So I would like to just show you, and Annie, I think you are still screen sharing. Thank you. I would like to just quickly show you what we have marked as previously marked Plaintiff's Exhibit 22. Are you seeing that? This PDF here? Oh no.
I can see it just fine.
Yep. Okay. I've lost my video. There it is. Can you see that, Mr. Linda James?
Yes.
Okay. And this is from Mr. Molnar, and you testified that he was the CEO of Clarity. Is that correct?
Chief Financial Officer.
Chief Financial Officer. And in this email, which you are copied on, this is November 2nd, 2019. This says that please be aware that upon execution of a definitive merger agreement, Clarity will receive funds to meet its November 30th, 2019 financial obligation of $225,000. Is that right?
Correct.
So this is the loan that you talked about, which I understand you're saying is a coincidence that it was the same amount. That's what was going to provide the funds to make that.
No, that's not correct. We sourced the money for the ultimate payment to for the $225,000 from an Australian investor / shareholder of ours, and we had that facility available to us. We also had some funds from our friends and family raise, and the combination of those, and if the merger had continued, we had access to that loan as working capital. So it wasn't our only source of funding, but it was an important source of funding.
But here, Mr. Molnar is telling Ms. Brown that that's what was going to be the merger, definitive merger agreement was going to be the source of the funds to repay Dr. Maida, correct?
Yes, that's saying that, yes.
And if you had all these other funds available, why didn't you make the payment on October 31st, 2019?
We didn't have them available at the time. we knew we could access them, but we didn't have them available at the time.
So I next want to show you what your counsel showed you as well, which is the letter of intent, which we've marked as Plaintiff's Exhibit 38. And this is confirming what you testified about before, correct, in Section 4, that you were going to receive a loan in the amount of $225,000, correct?
Yep.
And the only cash that Clarity was going to receive upon the definitive merger agreement was going to be this $225,000 loan, correct?
Correct.
And you testified also about the press release that Global issued. Did you review the press release before it was issued?
Yes.
And did you see any issues with it, or, you know, make any corrective statements with respect to anything in the press release?
I'd have to go back and look at the draft that I received and whether I made any markups or not to answer that.
Did you review it after it went out as well?
I certainly did, yes.
And at that point, did you feel the need to correct anything that was in it?
No.
And I'm showing you now Exhibit 43, which is, this is the press release, correct, that Global issued?
Yeah.
Same objection.
Yes, ma'am. You said you have an objection?
I said same objection. This is the same document that Mr.
Well,
Kaplan.
he's identified. He said he's familiar with it. Isn't he? Isn't that what I heard?
That's what I heard as well, Your Honor.
Go ahead.
Thank you. I'm going to scroll just to the top of the second page of this and highlight this paragraph for you, which says that concurrent with signing a definitive agreement, and this is saying that Global will provide a $225,000 loan, which fund shall be used by Clarity's operating capital to move towards building inventory to commence sales in early 2020. Is that correct?
Yes.
So Global is saying that this loan will be used for operating capital, not to pay back the loan to Dr. Maida, correct?
Correct.
But Mr. Molnar, the chief financial officer, had told Dr. Maida's counsel that the loan was going to be used to pay Dr. Maida, not for operating counsel. Is that correct?
Yes.
Sorry, just 1 second. Now, Global was is a publicly traded company. Is that right? On the Canadian exchange?
I'm not sure if it still is, but it was at the time.
And I think I heard you testify that you expected to go through an audit process as part of coming to a merger agreement, correct?
Correct.
And part of the audit and the merger agreement in general would be due diligence on both sides, correct?
Yes.
And you expected that Clarity and would have to get an audit, would have to open up their financial statements to Global for review, correct?
Yes.
Do you recall in December of 2019 receiving a request from Dr. Maida's counsel for financial information?
Yes.
I'm going to share my screen again with you. And that's we've marked as Plaintiff's Exhibit 27. Is this the letter you recall seeing? Asking for financial information?
Can you just scroll to the subsequent? Just scroll down a little more.
You can tell me when you'd like me to stop.
Yes, that's the letter.
And this is asking for tax returns, correct? Federal and state monthly cash
Objection, this is outside the scope of what we were permitted to question Mr. Linden James on.
Yes, ma'am. Tell me, Ms. Stone.
Well, Your Honor, this goes to essentially the likelihood of this merger taking place.
It actually has nothing to do with the likelihood of the merger taking place. These are invasive financial questions that Kaplan Cobb was insisting that that Clarity and RxMM produce before it would make good on the promise it had made back in November. It has nothing to do with the global merger.
Well, if I could finish my statement, this shows the likelihood of the global merger because these would be records that you would expect Clarity to maintain and to keep and to be able to provide to Dr. Maida, which she was entitled to. So we'll see under various agreements, if we're allowed to get into that testimony, which Clarity was required to provide to her, that they were not able to provide to her. So it's our contention that if they couldn't provide it to Dr. Maida, there was no reason to expect that they could provide this to Global as well, making a merger extremely unlikely.
All right. Okay. I'm going to sustain the objection. Let's move on. Anything else for this witness?
Just one moment. Make sure I have everything. You mentioned a little bit about this meeting in Canada about the IP, correct? Or not about the IP, about the merger.
Yes.
And that you felt that you had already told them you had this IP and you were concerned that you were going to lose it and didn't want to go through the meeting, correct?
No, I hadn't already told them that.
You hadn't told them that you had IP?
No, they had full explanation of business plans and executive summary of the business itself and its assets, its IP, its intentions. They'd had all that information before issuing the letter of intent. And as far as they were concerned, being the executives of Global and their advisor, they were happy with the idea of the transaction proceeding.
Had you
we were going there to take it to the next stage to basically try and conclude the transaction.
Had you told Global that the IP was serving as collateral under the IP security agreement?
Absolutely not.
You didn't tell them that?
I didn't tell them, I didn't inform them at this stage of any of the concerns that we were facing regarding the IP, because I believed that we were going to end up with a license, and I consulted our counsel in Toronto about what had occurred. And he said, well, are you going to end up with the rights to exploit the technology? And I said, as far as we know, we will. We haven't finalized it, but we will. And he said, then there's no need to introduce that at this stage.
And have you told Global that you had missed payments to Dr. Maida under the various forbearance agreements and notes?
No, we hadn't.
I have no further questions, Your Honor.
Just one final question, Mr. Linden James. Given that discovery hasn't started in this case yet, have you had an opportunity to retain an expert to provide an opinion on the scope of damages related to the merger with Global?
We haven't retained an expert at this stage.
Okay. Thank you.
All right, thank you. All right. Watts, anything else?
You're on mute.
You're on mute. I'm sorry.
No, I think that was the last part of the presentation that I was hoping to get before the court. So I think at this point, we're good.
Very good. Thank you. Is there anything you want to add, ma'am, in conclusion or an argument that we haven't already addressed in connection with the motion?
I don't think so.
Okay, Mr. Kaplan?
Your Honor, There's nothing that I would like to add substantively other than to just make the comment that I believe that the testimony of Mr. Lyndon James just confirmed precisely the fear that we had after investigating in more depth the possibility of entering into another licensing agreement with Clarisy. You just heard Mr. Lyndon James say that he had not disclosed with a prospective merger partner that the core asset of this company had been fully collateralized and that he had defaulted, or his company had defaulted under this document. That is obviously material information to any prospective merger partner. And so I would have great concern about having participated in that transaction. And it is frankly shocking to me that given that information, one would predicate a claim that this merger would have been consummated. So I'm frankly very shocked by the testimony. I think if you would permit us to call Dr. Maida, you would also hear that we continued our investigation and learned that Clarisy had no present financial information and had no financial information for the prior year. So what I think that you are beginning to learn about is the depths to which we had to be very careful, because our biggest concern after learning more information about this was having our client, Dr. Maida, be seen as participating in a fraudulent enterprise. And I think that the evidence that you have heard today confirms that. And should this case proceed, we obviously will be conducting further investigation into that. But for present purposes, I think that the best outcome for this case is to resolve our breach of contract claim, which is undisputed. You heard Mr. Lyndon James admit to not paying the required amounts and enter judgment against them on counterclaims and permit further proceedings to take place. If you would like to hear testimony from Dr. Maida, we're prepared to give you.
What her proffer would be.
Thank you, Your Honor.
Anything else?
Your Honor, I will just say to that, I don't think that the testimony of Mr. Lyndon James shows anything other than they were trying to enter into an agreement to fulfill
Well, I
their...
have his testimony, right?
Yes. Well, I disagree with Mr. Kaplan's characterization, but yes, you have the testimony before you, and I trust that you will hear that, and I'll leave it at that.
Okay, thank you. All right, thank you all. I'm especially grateful to the attorneys. You all presented very nicely, and I appreciate that. It's very helpful. And I promise we'll get you in order very shortly, certainly no more than 10 days from now. Thank you.
Thank you, Your Honor. We appreciate your time.
Thank you, Your Honor.
Thank you.